Error. touch it Yes, next.
Okay. Clear number 3.
My lord, the council is appearing through VC.
Please, your lordships, I beg to appear on behalf of the petitioner. There is one objection raised by registry regarding the memo of parties.
This is
If your
office
lordships
objection.
would just come to.
No,
Yes.
no, some office
The-
objections are there.
the-
Please have the office objections cleared. We'll take it.
No, your lordships, the office objection would be requires an order from this honorable court. Just have a look at page 9, memo parties. So the objection is, this is a contempt petition against violation of an attachment order done by respondents number 1 and 4. The objection is that only BPL Limited is a party to the execution, which is true.
What is the office
The
objection?
rest of the are the directors who are in control.
Please hold on. Non-compliance office objection title. To be proper. Accused number 1 to be proper and same. Yes, cost title of accused to be proper. What is wrong with that?
Yes. So the objection they have taken is that the execution petition is only against BPL, which is respondent number 1. And why you have added the other directors. Now, that is in terms of section 12 of the...
No, that's not the objection. The objection is something else. The AOR must look into the objection and comply with the objection. Objection is something else, saying that non-compliance office objection regarding cost title of accused number 1 to be in the proper form and the same to be clarified because only company has been made. There is no person. So please ask your AOR to do the needful. We'll take it.
No, your lordship, that's what I was pointing out.
See,
In terms of section 12.
Please understand, learned advocate, you are at a remote station. You do not know what is written here. Your AOR does not know. So please have the clerical things done. We'll take it up. All right.
My lord, I could mention regarding that accused number 1, I've given a clarification regarding that accused number 2 is the director.
Where have you given the clarification? It is not available.
It's there in the order sheet, my lord.
Do one thing. Go to the registrar judicial. We'll send the file. Clarify with him. If the office objection stands compliant, then we'll take it.
Much obliged, my lord.
All right. 1 week to comply.
Grateful, your lordship.
Thank you. Third time, 2 weeks to comply. Other 2 weeks mount. 4 2 weeks, 5 2 weeks, 6 2 weeks.
May I please, my lords, I beg to appear for petitioner in item 5. In fact, my lords, there are 6 office objections left, my lords, and the court fee is also made good. If my lords are convinced on the petition and the notice may kindly be issued.
Please comply with, no, sir. Please comply with, my lords. No, please comply with office objection. It's a PIL. There will be, you must comply with all office objections. If there is a problem, you see, we are telling for the benefit of all lawyers, wherever there is problem in the registry, you can always approach the RJ registrar judicial. He will solve the problem. If he puts up a note saying that he can't solve the problem, then court will give a ruling. Thank you.
Grateful. My lords, may I please request for a kind date after 1 week?
Of course, there will be a date on every file
convenient
now.
For the honorable.
Please give it in April whenever.
Grateful.
Yes.
For the appellant requesting 2 weeks time.
Yes, 2 weeks. Vishwanath, 2 weeks.
Yeah.
Nagaraja, 2 weeks. Devan Siddha, 2 weeks. Then 2 weeks. Orders GR Mohan. What is this?
Yeah.
What is this, GR Mohan?
Because this matter pertains to flexes, my lords, illegal holdings in the city. In the last date of hearing, there was a direction. They have filed a memo, my lords. BBMP was asked to submit a report. I think their report is ready.
Are you happy with that?
I pay for the petitioner.
Have you looked
at certain documents on last hearing date. This court directed.
No. Have you looked into the report?
Yes. I'll go through that report.
So what do you want now?
Now, as far as this report is concerned, there is a direction issued by this court on earlier 2nd August 2023. By virtue of that, I was asked to file my response, which I filed on last hearing date, Your Lordship. For that, they should give you response for that also. Apart from what now they are filing, it's a regular document with their complaints of that.
What is the matter about?
The matter pertaining to the illegal flex banner, which is being put in violation of the Karnataka Open Player Discrimination Act, wherein several directions were issued by the Sound Court. In spite of the direction, we are seeing unauthorized hoardings, all these things, even yesterday, today, it is daily happening. And also, FIRs have been registered under the KOPD Act also. But till
So what do you want today now?
today, let him respond to other memos which I have filed also, that's all.
No, I've served it to him. He has not even gone through the whole
If
thing.
I-
What else I do?
All right,
17 this matter.
please go through. If you have anything more to say, please state on the next date of.
Short date may be given.
Please file it in office.
Short date may be given, Lordship.
Mr.
Because it is pending
Ad-
since 2017.
All right,
4 weeks time.
advocate for such R2 submits that he has served a copy of the report and undertakes to file the same in the registry today. Mr. Mohan seeks some time to go through the report all on such and such date on date for
Lord, it's a rejoinder to this memo. My lord. It's a rejoinder, not a.
rejoinder.
Rejoinder.
Under
That to my memo.
under the opening sentence, he got Mr. Mohan submits that rejoinder has been filed by rejoinder has been served by Mr.
That is
Sanjeev.
on 21/12/23.
That's all right, Sanjeev. He seeks time to
Yes,
go through the same 2 weeks or 3 weeks on date.
some date.
Yes, next. Only
Please, my lord, herein, notice
No.
to be
R5.
R5. Here in the postal share of the registry is that it is already delivered, my lords. And I think I could contact D. Nagaraj, who generally appears for SEA. He said that he's in other courts. I think notice is ordered, he will appear on the next date, my lords.
All right.
D. Nagaraj.
No, but let him file Wakalatnama. We'll show his name. No problem.
Usually they are not in the habit of filing wakal, the only memo will be filed. So,
What do you want now?
so no, it may be D. Nagaraj name may be shown in respondent
Mr.
number 5, my
Pardes
lord.
says, submits that Sri D. Nagaraj, standing counsel for R5, has informed him that he shall. No, but that will be a very loose order. Let's not do that. Let him file it. We'll
Please.
post it in 2 weeks. Please ask him to file some memo, something so that.
Please, my lord,
Yes, 2
please, my
weeks.
lord. And at the same time, R3 is not represented by learned government advocate because it is also showing in the
1 to 3 into the.
R3.
So R3, what do you want? You want fresh notice?
Yes, my lord. No, I think learned government advocate will take it. It's a deputy
Itaralla
director.
ಅವ್ರು. ಇದಾರಲ್ಲ ಅದ್ರಲ್ಲಿ ತೋರಿಸ್ತಾ ಇದೆ government for R1 to 3.
I'm sorry, R4, my lords. R4.
So notice is not ordered.
Yes, that's what, because
right.
now,
All right.
since,
Notice to R4.
please, my lord.
Government,
Yeah, I can take.
you take notice for 4?
Yes.
All right. AGA accepts, GA accepts notice for R4. Awaits service on R5.
Your Lordship appear for the petitioner. In this matter, kindly, there's an order passed by the court on 23rd March 2022.
No. You must now
The
file.
funds, 110 crore,
Please understand, you must file this translation, please.
that I filed, Your Lordship. That is,
File it.
that I filed. And
Mr.
my
Mo-
request is that now what was filed in 2021, the stand petitioner, roads, everything, still they are not done anything BBMP. I produced the photographs. So there was an order passed by the court on 23rd March 2022, Your Lordship, wherein they have submitted the 110 crores have been earmarked for this Dasarali Assembly constituency for improvement road. Court record that submission, 23rd March.
So
That
what
is
do
the
you
reason
want-
I moved it.
what do you want now?
Now, same, they have withdrawn that fund which they have been sanctioned, and now withdraw. Yes, it's not there. Government. No, same photograph, same condition, roads are there. I produced the photograph.
One minute. Today, what is the order that you are asking for?
Now I am asking that my prayer earlier, what I sought for improvement of the roads and which are all in bad shape, which was there in 2021. Again, in last week with photographs and Google on 13th, which I produced, Your Lordship. Same situation it is there, Your Lordship, with date on second, Your Lordship, 7th February.
What is the solution? What
Memo-
do you want?
They are to look at, they are to asphalt all these roads, Your Lordship, but there are 7 wards are there.
Who has to do that?
The BBMP has to do it. They are given an undertaking.
Well, the funds have been sanctioned, but it's actually below for, it's cleared for the purpose of asphalting. I will get back to your lordship, how much time they'll complete.
When will you complete?
The lordship, I have this by today after tomorrow. I'll come with a time frame.
All right.
What is the
Mr.
position?
Ramesh submits that the BB shall submit a timeline with regard to the completion of work. When do you want?
Lordship, after day after one or next week.
All right. He will file a timeline within which they'll complete.
Yes.
All right.
Because now they have to clarify because.
Aitala,
But- And that office objection may be kindly be.
no, you
I
have
filed
to,
the typed copy ಹಾಕಿದ್ದೀನಿ.
I'll
With
put up,
submission.
Mohan submits that translation copies have been filed, office to verify.
Yes, sir.
Next line, out Barpolli. Mr. Ramesh seeks a week's time to file the report.
Yes. Sir.
That's all. Yes,
Let
next.
them file. What trouble?
Prakash.
Please. Amendment application is filed.
But I need to file objections.
PIL amendment application, what objection you will?
But I need to seek instructions from
In
the
fact,
authority.
the last
I'm just
occasion,
asking you, what is a prayer?
my lord, in the last occasion,
What is a prayer?
prayer for, my lord, construction of rail over bridges across 4 spots where Bangalore.
Construction of?
Rail over bridge. In fact, on the last occasion, I brought to the notice of my lord, sir, wherein at 4 points.
Oh,
when
it's
the-
been blocked.
Yes, yes, my lord. So
You
that
want
is
to
what-
add something? What objection you can have? No, sorry. You can't have frivolous objections.
In fact, the learned.
PIL is not, it is not an adversarial litigation.
I agree with the fact, my lord, but the thing is that, my lord, I need to seek instructions from.
You
the
must
authority.
tell us in law, then we will give you time.
Last time was
There is
same.
no,
prayer.
your client may
Other-
say whatever. You must tell us that this you must be entitled to ask for time.
Kindly pass on, my lord.
No passover, sir.
But
We have
senior-
got, please have some mercy. We have got 3 lists. In first list is 110 matters. We are allowing this application.
Please, my lord, senior will.
Do what you like.
Please, my lord.
Mr. Young advocate, you must have some application of mind when you are arguing a matter. PIL matter amendment application, you want to file objections. We are very sorry about it.
In fact, they were instructed to submit a report regarding.
What do we do, Mr. Prakash? Tell us. You get the objection or whatever. Mr. So-and-so desires to, we will not say anything. As prayed for by respondent, call next week or week of next one, date code. Yes.
Oh, please.
Yes.
I am for the respond number 2.
For the respondent number
Lords,
3 and 4.
Number 5.
My lords, a short issue, my lords. The members of the municipal council had submitted their resignations.
No, there is 1.5 page full of compliances, something is there. Please examine that, then.
But sir, that is so far as the respondents are concerned, my lords, so far as the appellants are concerned, matter had come up.
What is the
Lords,
matter about?
Lords, it's a very short issue, my lords.
A copy is not been served.
Lords, I'm not pressing on, it's a very short issue, my lords. The members of the municipal council had submitted their resignation. Then anti-defection law was invoked against them. The president has now filed the president of the party says that their resignation was never accepted. Without holding an inquiry, my lords, the deputy commissioner has said that we are all disqualified. That's all the issue. Matter has to go back to the deputy commissioner because it's an admitted fact that deputy commissioner has not conducted any inquiry.
Yes.
Supporting the argument of my
They're supporting,
senior
yes.
counsel.
Who is opposing?
My instance,
Who is opposing?
I am the complainant.
Ah,
I am
yes.
also complained before the
But,
deputy commissioner.
No, they
Mr.
are not the complainant,
Yes,
but
yes,
we
sir.
are the complainant. Now they want to substitute themselves.
Can we send it back to the deputy commissioner?
No, my lord, there is already inquiry is held.
No.
There was a full-fledged summary inquiry was held, my lord. They have appeared before them and.
So you are contesting that?
Yes, yes, my lord. There has to be here.
Then you
But
come.
Matter has to
Just-
be heard, my lords, because the
That has to
TC
be
has
heard.
passed a detailed order.
Permitted to,
The judge has
Heard,
considered.
no problem.
permitted to produce 2 important
Please
documents.
don't waste our time
The
here.
official act.
Please have all that in the, file it in the office.
Lord, that concludes the matter. As a matter of fact, the present president, if he says,
Ravi,
With
if there is a
lordships.
contentious issue, we have to hear the matter.
I'm in your lordship's hands. That's what I can say.
Learned GA submits that the matter requires hearing, detailed hearing, call on such date. So, by consent, call on such date. Yes, Renuka, await service.
In fact, I moved this matter, my lord. There's a warrant, my lord, issued. And it was issued on Thursday, my lord.
About what?
My lord, there is a back wages reinstatement with back wages. As far as reinstatement is concerned, I've reinstated him, my lord. He's been working.
How much back wages?
My lord, 50%, my lord. Is
Amount, madam.
My lord, 5,67,000.
How will a poor man sustain without you paying?
My lord, he's working with me, my lord. He's getting the salary with all benefits, my lord.
But
It's
he can
only-
use that
my lord,
5 lakhs for some fixed
He's
requirement.
not entitled to is my submission because this is a case of non-issue of tickets.
Then you deposit the money, let us see.
My lord, 2 2 lakhs, my lord, and a protest has been issued, my lord, check has been issued, my
To
lord.
him.
On, no, to the, it has been deposited in the civil court, my lord, because the matter was not taken up, my lord, on Thursday. It was in the second list, my lord. Therefore, on that day, my
You
lord.
have given him 2 lakhs?
No,
Or it
2 lakhs, my
deposited
lord,
it?
was given to the Amina, my lord, in the name of the city civil judge, my lord. Therefore, my lord.
Naturally, deposit the full money.
My lord, I have a good case on merits, my lord. It's a public company, my lord. Therefore.
What do you want now?
In fact, my lord, I have served a copy on him, my lord.
What do you want, madam? You must.
Stay of the award as far as back wages is concerned.
2.5 lakhs she has deposited.
2 lakhs, my lord.
Only, I will not take you lot much time. Only one submission. 2013 dismissal. Even today, even though he is working, no, my lord, it is on the last known wages basis. 10-11 ವರ್ಷ ಆದ್ಮೇಲೆ ಹಳೆ ಸಂಬಳದ ನಾನು ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. This is my problem. Therefore, my lord, let them deposit the entire amount. 50% of that may be ordered to be released.
My lord, nothing remains, my lord. In fact, my lord.
How many years most?
My lord, in fact, my lord, the matter may
How
be.
many years service he still has?
My lord, he is only 42 years, my lord.
So, even if you give 50%, you can recover in his salary if he loses.
My lord, whatever that is deposited, my lord, may be ordered to be.
All. And the
My lord,
50%
the remaining amount may be stayed, my lord.
all. Mr. Renuka submits that rupees 2 lakhs has been deposited with the labor court, is it?
My lord, in the civil court, my lord, in the, before the,
That's it.
In execution proceedings.
in EP number 143 of 2023.
In 143 of
23, my lord.
2023. He has no objection for the said amount to be released in favor of
My lord,
respondent.
Can it be a court order?
All right. He submits that deposited such and such. Mr. Naik submits that the petition, the said amount may be released to the respondent. The same is opposed by Renuka, full stop. Admittedly, the respondent has been directed to be reinstated and a back wage of about rupees 5 lakhs, is it?
Yes,
About
5,67,000, my lord.
5
That is computed by him, my lord, by the workman.
According to you, how much, madam?
My lord, in fact, they have not computed, my lord. I'm so sorry, my lord. This is a.
And back wages of 50% back wages, is it?
Yes.
50% back wages has been ordered. According to Naik, it works out to rupees 5.67 lakhs. Admittedly, respondent is aged 42 years, correct?
Yes, yes.
And working, he has been reinstated. In the circumstances, the amount deposited in the EP be released in favor of the respondent.
Which is subject to the result of the.
Subject to the result of the subject. Yesterday, the monthly salary.
ಈಗ ಅವರು 18,000 ಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಕಾರ್ಡಿಂಗ್ ಟು ಮೈ ಇನ್ಸ್ಟ್ರಕ್ಷನ್.
My lord,
subject to outcome of the writ.
The award may be stayed, my lord.
Award remains stayed, shall remain stayed. Yes. ಉಳಿದಿರೋದೆಲ್ಲ ಡಿಲೇ ಇದೆಯಾ ಅಂದ್ರೆ ಡಿಲೇ ಕಂಟ್ರೋಲ್ ಮಾಡ್ಬಿಡು. ಎಸ್ ನಾಯಕ್
ಅವಾರ್ಡ್ ಸ್ಟೇ ಎಕ್ಸೆಪ್ಟ್ ರೀಇನ್ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೆಲಸ
ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಹೌದು
ಆಯ್ತು. ನಾಯಕ್ has no objection. IA allowed delay condoned. ಅದೇ ಯಾವ್ದು ನೋಡ್ ಹಾಕಿ. IA 1 of 22 allowed delay condoned. Respondent has been reinstated. Payment of money remains stayed. Shall remain stayed. Yes, Rudappa.
Pay for the respondent money.
ಅರ್ಜೆಂಟ್ ಅಂತ ಕಾಪಿ ಸಬ್ಮಿಟ್.
All right. Nayak permitted to file wakalatnama in 8 weeks.
But
for appellant, yes, you must do the needful acknowledgement, etc. 2 weeks. For process, why are you moving the court?
We have paid 3 times.
That's all right, sir, but please clarify with the registrar judiciary.
Respondent is also appearing through.
So what do we do? See,
We'll pay.
Process everything. For process, why are you moving and getting the matters listed here?
Third, the copy to the council.
We'll dismiss this, mister. We cannot just handle these matters like this. 4 weeks to do the needful. Govind Raja.
For petition, my lord.
No, 1 minute. Let us see. 1 minute. There are still council submission, etc., etc. Matter be placed before RJ. Please go before RJ. Get all your clarifications done there. Yes, Sunil Kumar.
Learned single judge, this is an alternate remedy.
1 minute. Learned advocate, what is the alternative remedy?
22, page 20.
What is the matter about, madam?
The matter is about conversion, which has
Ah.
been granted, and there's an
No
alternate
urgency.
remedy.
No urgency, you argue,
Oh,
comma
Much obliged.
19.
For the respondent, they have undertaken to pay the,
Who have undertaken?
your lordship's passed a peremptory order last.
Oh, yes. Oh, doctor.
Sir,
Yeah,
sir,
given the
Different
check.
doctor today, my lord.
Dr. Sunil Kumar is my colleague, and I'm Gangadhar Malappa, one of the director of the hospital, sir.
Have you paid the, have you given the demand draft?
No, sir, just, sir, one thing I'll tell you, sir. The genuine reason, he has discharged Saturday, sir. And now it's 100% we require.
Have you deposited, have you given the demand draft?
No, sir.
No.
We were
Thank
in the process, sir. 100% we are going to give in another 10 days, we are going
All.
to complete, sir.
But
So it's a-
one Dr. Gangadharappa appears today.
So- Please, sir, kindly request, sir. Sir, 65 ಫ್ಯಾಮಿಲಿ ವರ್ಕ್ ಮಾಡ್ತಾ ಇದೆ. ತುಂಬಾ ನಾವು ಜಿನಿಯನ್ ಆಗಿ 3 years ಇಂದ ನಡೆಸಿದೀವಿ. ಯಾವ್ದು ತೊಂದರೆ ಮಾಡಿ.
ಅವರಲ್ಲಿ ಹಿಂದಿನ ಡಾಕ್ಟರ್
ಸುನಿಲ್ ಕುಮಾರ್ ಇವತ್ತು ICU ಅಲ್ಲ ಸರ್, ಇವತ್ತು ಒಂದು ಕೇಸ್ ಇದೆ, ಕೇಸಲ್ಲಿ ಇದೆ ಸರ್. ಅವ್ರು
ಸರಿ.
ಮಧ್ಯಾಹ್ನ ಬರ್ತಾರೆ.
ಬರ್ಲಿ.
ಅದಕ್ಕೋಸ್ಕರ.
ಮಧ್ಯಾಹ್ನ ಯಾವಾಗ ಅವ್ರಿಗೆ ಅನುಕೂಲ ಆದಾಗ ಬರ್ರಿ.
ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಸರ್, ಇದು ಲಾಸ್ಟ್ ರಿಕ್ವೆಸ್ಟ್. ಫೈನಲ್ ಎಲ್ಲಾ ಫ್ಯಾಮಿಲಿ ಎಲ್ಲ ಬೀದಿಗೆ ಬಂದ್ಬಿಡುತ್ತೆ ಸರ್.
ಹೌದು, ಬರುತ್ತೆ. ಸ್ವಾಭಾವಿಕ.
ಈಗ ಲಾಸ್ಟ್ 4 years ಇಂದ ನಾವು ಮಾಡಿದೀವಿ. ವಿ ಹ್ಯಾವ್ ಪೇಯ್ಡ್ ಹಿಮ್ 6 to 7 crores ರೆಂಟ್ ಕೊಟ್ಟಿದೀವಿ. ಈಗ ತೊಂದರೆ ಆಗಿದೆ, ತಪ್ಪಾಗಿದೆ.
ಇವಾಗ ಯಾವ್ದಾದ್ರು ಡಿಡಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಈಗ ಕೊಟ್ಟಿಲ್ಲ. ಈಗ ಕೊಡೋದಕ್ಕೆ ನಾವು ಎಲ್ಲ ವ್ಯವಸ್ಥೆ ಮಾಡಿದ್ವಿ ಸರ್. ಜಿನಿಯನ್ ರೀಸನ್ ನೆಕ್ಸ್ಟ್ ಮಂಗಳವಾರ ಅವ್ರು ಬರ್ತಿದ್ದಾರೆ. ಬಂದ ತಕ್ಷಣ 3 days ಅಲ್ಲಿ ನಾವು ಕೊಡ್ತಾ ಇದೀವಿ ಸರ್. ಜಿನಿಯನ್ ಆಗಿ ಮೊನ್ನೆ ಡಿಸ್ಚಾರ್ಜ್ ಆಗಿದ್ದಾರೆ ಅವರು ಅಪೋಲೋದಿಂದ. ಒಂದು ಫೈನಲ್ ರೀಸನ್ ಕೊಡಿ ಸರ್, ದಯವಿಟ್ಟು ಒಂದು ಆಪ್ಷನ್. ಹಾಸ್ಪಿಟಲ್.
Sorry, doctor, we can't help you in this. We cannot do anything.
ಇಲ್ಲ ಸರ್, ಇದೊಂದು ರಿಕ್ವೆಸ್ಟ್ ಸರ್ ತಮ್ಮ ಹತ್ರ. ಯಾಕಂದ್ರೆ ನಾವು ಯಾವ್ದು ಇನ್ನು ನೆಕ್ಸ್ಟ್ ಅಂತ
Please
ಕೇಳಿಲ್ಲ.
don't waste our time. We have, last time one Dr. Sukumaran had come, we have recorded his statement.
ಪ್ಲೀಸ್ ಬರ್ತಾರೆ ಮಧ್ಯಾಹ್ನ.
ಬರ್ಲೇಬೇಕು. Sir.
Good.
2:30 we'll call Mr.
Appellant disbursement. Not office objections with regard to the additional documents.
Objection, we will not consider office objection.
Not
Go
a-
to registrar judicial,
Please,
please.
please.
Office objection clearance in
Meantime, not delay is there, my lord.
whatever, unless it comes with the clearance of office objection. Sir, not possible to do in last 2 days, sir. Please cooperate. Do we deal with office objections? Go to the registrar judicial. Thank you. Memo for withdrawal.
My lord,
Yes.
and for the petitioner.
Withdrawing?
Yes, my lord.
Withdrawn, dismissed.
Withdrawn. Withdrawn, sir?
Withdrawn, dismissed. What else you want?
No, my lord.
That's all?
Okay.
Thank you. Next.
Representing the state in the matter, my lord.
Oh, yes, 1 minute.
ಮೆಮೊಗಳಲ್ಲಿ ಲಾಯರ್ ಸೈನ್ ಹಾಕಿ ಅವ್ರು ಸೈನ್ ಹಾಕಿ KR ನಂಬರ್ ಬರ್ಸಿ.
You are the advocate on record. Prakash Angdi.
Yes,
Who is
my
the,
lord.
are you also on record?
No, my lord.
You are not signed the memo, madam. You meaning the advocate.
My lord, I want to express it as the office objection says that the amount has to be paid in the court. We have taken it as a settlement outside the court, and we have,
What precisely you want? You want to withdraw the appeal?
yes, my lord.
Then ask the advocate to sign that memo, that's all.
Yes, sir.
All right? Come.
ಸೈನ್ ಇದೆ.
Have you filed the wakalatnama? No? Please ask your advocate to come and sign Prakash Angdi, that's all. That's all. Ms. So-and-so submits that Mr. Prakash Angdi will fix his signature in the memo. You will do it today?
No, my lord.
When?
A short date may be given.
When? 2 days?
Yes,
In 2 days, he will come and sign in the office?
and say.
No problem? All right. Within 2 days, granted, appeal stands dismissed as withdrawn. Yes, next. Andre, one line particularly. Office objection is that advocate has not signed the memo, whereas the appellant has signed. Full stop. So-and-so submits that in 2 days, signature will be affixed. Submission accepted, appeal dismissed as withdrawn. Next.
Representing the state in the matter.
I
my lords.
appear for the complaint.
Yes, madam.
This matter, my lords, Mr. Vikram Huilgold is appearing. He's not in station today. This is the case where the title
All
is
right.
said to be
Your
seen. Day after
lordship's
tomorrow,
court
Wednesday,
text, the matter has
Wednesday
been
or
posted.
Thursday is my only
If
request.
advocate general has to come, we have to give some, they
Wednesday
will have
or-
several matters, madam. Please cooperate. 1 week, next week or week after next.
Please.
Mr. Bhanu Prakash submits that.
May be given.
All right. Additional Advocate General has been briefed in the matter. Call on such and such date. Thank you. Sekhar,
In the writ appeal, my lord, we have settled the matter, my lord.
settle.
And we are filing a joint memo, my lord, duly signed by the workmen.
Correct.
So in view of that, my lord, contempt would not survive for consideration.
Correct. Mr. Renuka submits that matter has been settled out of court. Correct?
Joint memo is filed, my lord.
All right, has filed a joint memo which reads as follows, full stop. In view of the above, in view of the same, nothing further survives. Full stop. Shekhar has no objection, correct?
He signed, my lord.
Party is also present, all right.
They have also signed, my lord.
Fair enough, madam. A joint memo accepted, CCC closed.
Writ appeal closed.
Connected writ appeal is there, is it?
Writ appeal ಅಲ್ಲೇ ಇದನ್ನ file ಮಾಡಿದ್ದು.
Oh, writ appeal ಅಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ?
Joint memo.
Close ಮಾಡ್ಬೋದಾ ಯಜಮಾನ್ರೆ?
Compliance within 2 months ಏನು ಹೇಳ್ಬಿಡಿ ಸರ್. ಇದೇನಿಲ್ಲ.
Compliance in 4 weeks ಅಂತ ಮಾಡಿ. We'll deposit that in 4 weeks.
28,000 ಕೊಡಕ್ಕೆ ಎಷ್ಟ್ರಿ ಮೇಡಮ್?
ಕೊಡ್ತೀವಿ ಸರ್. We'll deposit. This is in addition to what has already been paid. In addition is
If you are agreed, you must give the, madam, what is the settlement if the old man has to come to your office and your officers, it will.
But the court proceedings have been muted. We can't hear the court.
1 minute.
Land is
What has
acquired,
happened?
it cannot be allotted for a private purpose.
Mr. Nawadgi, can you hear? Please ask him to check.
Lord, I am there, Lord. I can hear, Lord.
You can hear, yes, fair enough.
Yes.
Yes, what is this? Mr.
After
Holla?
the- After the land is acquired, it cannot be allotted for a private purpose.
Fair enough, but there are Mr. Mr. Holla, you and Mr. Nawadgi, 3 senior advocates.
Advocate General had to come and make some.
So Advocate General, so 4.
Lords,
Please spare us, not possible.
Lords, if your lordships were to recollect, this is the
Oh,
matter.
5.
Lords, Lords, this is the matter where your lordships are directed because there was an undertaking given, my lords, before the court, before the coordinate bench The
Yeah.
grievance is that the same is not complied with.
But
Lord,
it has to be
now,
heard, no, Ravi.
of course, if your lordships is for any reason adjourning, my lord, there was an interim order which was granted where the Advocate General said that the Deputy Commissioner will not precipitate the matter on the resolution dated 16/1/2024. That was granted in the previous hearing. Last date of hearing, since the Advocate General said that the Deputy Commissioner is coming to meet the Urban Development Secretary and thereafterwards.
What is the matter about?
Lords, this is the matter, if your lordships were to
Sites.
recollect, my lords, the pursuant to the undertaking
Allotment
given
of
for
sites.
allotment of 142 sites, my lords, 42 sites have already been registered. Remaining possession certificates as well as the allotment letters are issued. Sale deeds are required to be issued. At which stage we have approached, my lords. There are undertakings. This is. Lords, this order, this is an order which was challenged.
Public, but it can't be for a private dealing. Covered
Lords,
by the private property in Supreme Court, 2016, 11 and 379.
That government
Lords,
order was.
my lords, this is the property, this is the property, my lords. A revenue layout having been.
Advocate General is also here. Yes, what is that?
Manoj, because of the session, Manoj, they're not able to take a decision in the matter, Manoj. They're saying the 30-year-old, it comprises of lot of documents, lot of litigation. In fact, they spent some time, they need another 2 weeks, they're saying, to take a decision in the matter.
Let the Deputy Commissioner may not precipitate pursuant to 16/1/2024 resolution where he wanted to resign the resolution which was undertaken to be implemented by the division bench before the division bench of this Honorable Court. Number one, that order was challenged by the writ petitioners and that is confirmed by the Honorable Supreme Court with the participation of the state government.
Yes.
So therefore, my lords, that resolution, withdrawing the resolution of 23/1/2023 is a resolution, my lords, which is subject matter of a judicial order at your lordship's hands.
You are appearing for whom?
Out.
Owners of?
Original owners. What did the DC want? He's already sold the property to a third party. He wants to come again.
No. You have filed an application, is it?
Yes, my lord.
Or?
My lord, it's like this, my lord. Land
1 minute. No, you are coming today. You will get your turn.
Opposed to public policy, it is.
No, Mr. Lakshmi Narayan, today you have come, so we will have your turn. Yes.
It's like this, my lord. The government has to take a decision as to whether they want to retain. Ultimately, my lord, all the landowners and the revenue site owners have lost the litigation. The only thing, there's a resolution of 97 which has been set aside, but 2023 there's a fresh resolution which is passed, my lord, which says that again the government has to take a final call whether they want to allot the lands to the revenue site holders or not. That, in fact, I saw twice, my lord, because of the assembly and various things, we are not able to take a decision. Another 2 weeks, my lord, we'll take a decision, then they can start arguing, my lord, where the at least one person.
I just wanted to say this, my lords, in a contempt proceedings, there is no question of arguments because there is an undertaking which is there. Undertaking order was challenged before
What
the
is
Honorable
the
Supreme Court.
undertaking?
My lords, the undertaking given is to implement the resolution dated 23/1/2023.
Who has to execute?
Lords,
Who has to do
Lords,
that?
I represent the commissioner. I represent the commissioner, my lords. I was the one who had given that undertaking. And the last few occasions, my lords, we have been unequivocal in stating that we are ready to implement that.
Then implement it. Who is stopping you?
No, there is an order of interim stay granted by your lordships. There is an order of interim stay granted by your lordships on the resolution, Lord. I have been repeatedly saying if that order is vacated, we will execute the sale deeds, Lord, subject to what the lordships.
Great respect, my lord. It is not the commissioner's private property to execute sale deeds, my lords. With great respect, my lords. Government has to take a decision, let them take a decision.
Whether there is an undertaking.
Well, how can any individual give an undertaking saying that he will give alienate the property belonging to Muda, my lords?
Here before us.
My lords, I wanted to say this, the state government is a party to the undertaking.
We may be a party, let the government take a decision, my lord.
State government.
There was a government order. That government order was set aside by this court. Division bench confirmed it. This, my lord, commissioner says, I will now implement that order. Subsequently, my lord, the Muda itself, my lord, has passed a resolution that we will not be doing so. That all that is suppressed by, my lord, the commissioner. Commissioner is playing, my lord, truancy.
I really don't understand,
he's the
Milords,
one who
because,
came before
Milords,
Lordship and
the
gave the-
resolution was passed on 23/1/2023 was placed before the review petition, in which the state government was a party. Milords, in the review petition, while it was being disposed,
No, let us not get into this new things. What is the last order of the court?
Milords, the last order of the court, which we are now complaining of, is that they have undertaken to implement the resolution. That is the final order.
Pursuant to?
Milords, that is pursuant to the resolution of 23/1. After that, there is one more undertaking given before your lordships.
No, 23/1?
2023.
No, that is
Now, the last order.
That doesn't.
Advocate General said we will not.
No, one.
I will.
Let Advocate General. See, what is the last court order?
Milords, the last court order in your lordship's hands, Milords, says that the Advocate General will have to get
No,
instructions.
sir, not here.
Please, there. Milords, the last
That you
order is
didn't-
to implement the.
What we are asking.
Lordship, my apologies. Yes, Milords.
See, execution of a particular order take place. That's how if it is not executed, there will be violation of the court order.
Lordships.
Fair enough?
Yes,
Right.
Milords.
So if that, which is that executable
292.
order?
Lords, page number 292,
Putting.
Milords.
Of our compilation, I made it easy, my lord. Our compilation, my lord. So all the orders can,
292,
my lord.
Number 292, para 7 and 8.
Can I read it, my lord?
1 minute. 292.
291, your lordships may kindly take, Milords. Para 6 and onwards.
Para?
Para 6 and onwards, the bottom of the page at page 291.
Yes.
Just quickly read through this. Learned
all
Senior
right.
Counsel for the review petition submits that the review petitions are not seeking review of the judgment dated 22/23 in the court in writ appeal number so-and-so, but only seeking liberty to Mysore Urban Development Authority to act in terms of the resolution dated so-and-so past by it. The aforesaid prayer has not been opposed by the learned High Court government pleader as well as the learned counsel for the Urban Development Authority. Lordships may kindly mark the sentence. The aforesaid prayer has not been opposed by the learned High Court government pleader as well as the learned counsel for the Urban Development Authority. In view of the subsequent events that has taken place after the judgment dated 27/2/2023, we direct that notwithstanding the judgment dated 27/2/23 passed by this court in writ appeal, it would be open to the Mysore Urban Development Authority to take action for allotment of the sites in favor of the writ petitions in number so-and-so. At this stage, counsel for the Mysore Urban Development Authority submits that suitable action for allotments will be taken in terms of the resolution.
So this is the last order.
This is the last of the orders.
Executable order.
Yes, this has become final because it was challenged by the writ petitioners, Milords, before your lordships, and that is confirmed by the Supreme Court. This order is not disturbed, and even that Supreme Court's order was passed with the participation of the state government.
You also wanted to rely on 292.
Please, my lord. That's what, my lord.
Ravi is also.
I didn't want to rely on what is.
You wanted to show.
So the thing is, my lord, what is that contempt they're saying in this court? They have lost the case. No, what the learned single judge says, it would be open to Mysore Urban Development Authority to take action for all of it in favor of the petitioner. What they do in 2023 is, my lord, they adopt the resolution of 1997. 1997 resolution says, take the approval of the government. I'm not going whether it is set aside or not, like, assuming it is valid. 1997 resolution says, take the approval of the government. That is why I made two submissions on the earlier, because ultimately it boils down to, if you admit 1997 resolution also, if it is valid as on today, approval of the government is required.
That is why we are very categorically asking. The executable order is WP 523-662.
Correct, I bowed down to you, Lordship.
That is the executable order.
Please, my lord.
So what is the direction in WP 5152?
The executable order is only in RP number 130 of 23.
In that case, my lords, the writ petitions of the landowner and the revenue site owners has been dismissed. That is Mr. Holler's client and Ravi Shankar's clients have lost the case. In a review petition, my lords, this observation comes for the first time. Assuming that is, according to me, there is no contempt case at all. Assuming it is a case of contempt, what needs to be done is the resolution of 1997, whether government approves or not, depending upon that, allotment will arise, my lords.
Yes, that's the standard.
I will just make this clear.
Let him answer whether valid or what.
Paragraph number 8 is the operative portion.
Yes.
Lords, I have read paragraph number 6. The government had absolutely no objection for allowing the prayer. And this is the paragraph number 8 is the undertaking given. Undertaking is as good as an operative portion of the orders of this honorable
What
court.
is the undertaking?
Undertaking given is suitable action for allotment of site shall be taken in terms of the resolution within a period of 8 weeks. So they had to allot the sites. Now I just want to go a step further and say this, Minots. Had it ended here and they came and contested for the first time, it's a different matter. What they did, they came before this honorable court and gave further undertaking saying that we are going to implement the resolution. Once the matter was before the coordinate bench. Then, my lords, they executed sale deeds for 42 of the site owners. Insofar as the remaining 100 sites is concerned, they issued the allotment letters. So what is remaining is execution of the sale deeds in respect of the remaining 100.
Coming in the way.
My lords, now what came in the way is, it is at this stage, the writ petitioner challenged the resolution dated 23/1/2024 by not producing the copies of the orders which were passed in RP number 135 of 23
Right.
and their challenge.
What is coming in your way?
Lords, what is coming in the way is an interim order. Now the corporation, as the MUDA submitted, my lords, MUDA says that since there is an interim order which has been passed in the other writ petition where senior counsel Mr. Holla appears, therefore our hands are tied. We are unable to execute the sale deeds is the stand taken by MUDA.
No, my lords, commissioner thinks he is above the MUDA, my lords, with great respect. Capacity execute sale did not be above MUDA.
There is already an undertaking. I really feel, no, there is already an undertaking.
1 minute. If WP 51523 of 662 of 2015 is the last executable order.
Lords, that is dismissed.
Lord, that
There
is
is no
not,
execute because if your lordships go by that, Mr. Holla's client and Ravi Shankar's client have lost. MUDA became the owner of the property. Now what they're saying is, even though the MUDA succeeded, land should go back to them.
Lords, I'll just clarify
That is
this.
what it's saying.
Operative portion or the executable order is the one which is passed in RP number 135 of 23, which I read to your lordships at page number 291, 292.
Correct.
So that is the operative portion which I am complaining that has not been complied with in the contempt proceedings. Once the contempt notice was issued, they came back. This honorable court started asking them as to what is that you are doing in this matter. Lords, the matter was heard for a while and thereafterwards the council said that we will implement the order which was passed in RP number 135 of 2023. After this undertaking was given, then the matter spilled over and 42 sale deeds were executed and about 100 allotment letters were issued. It is at this stage again when the matter came.
50, 60 you must get.
Yes, another 100 millards. This is 140. Another 80 persons are required.
Yes.
Another 80 persons are required to get the sale deeds. Allotment letters are also issued to them. Now, this is where the status stands. So far as the writ petitioner is concerned, he wants to challenge what is in 23/1/2024, what was in 1990.
Subsequent purchaser or
He's a subsequent purchaser after the acquisition. The denotification being withdrawn was challenged by him and he challenged it, not up to the division bench, lost it. Then he filed a review petition.
subject to what learned senior advocate Mr. Holla says, we'll deal with that.
Lordships.
But now we understand the controversy appears to be between you and Mr. Shashi,
MUDA.
The government.
The
the
government,
advocate.
Milords, I'll put it this way, Milords. The government came to be introduced because the deputy commissioner, the chairman and the commissioner of MUDA appeared to be at loggerheads because the commissioner said that there is an undertaking which is already part of the record of this honorable court. Therefore, that has to be done. Deputy commissioner is also a party to the same resolution of 23/1/2023. Very deputy commissioner, very officer, who subsequently ratifies.
Property belongs to whom?
Milords, the property belongs to MUDA. MUDA acquired the property. After the MUDA has acquired the property, there was a need of denotification. Denotification is withdrawn. That the withdrawal of denotification is challenged up to division bench. That has become final. But an RP is filed, Milords, that is also still pending.
Can I make it clear, Manoj?
Yes.
It's not in dispute. MUDA is the owner.
Yes.
Now they want to claim land right over them.
Milords, for 42 sites, presently I am the owner. No, for 42 sites.
Ravi Shankar wants to interject.
Milords,
He wants to interject. It's not fair.
Milords, I will say this, Milords, for 42 sites, I am the owner.
Please hold on.
Please.
Please hold on. Please hold on. Mr. Holla wants to say something. Yes, please say.
Please look at the order that was pointed out to your lordships at page 292.
290.
Resolution is in the teeth of the order passed by your lordship. Where your lordship what's the government order?
292.
Yes, my lord. Please see my lord, paragraph 6 only. Fourth line is at page 292.
Yes.
Urban Development Authority, my lord, he says we will act in accordance with the resolution of 21-3. That resolution of 21-3 is in the teeth of my lord, the order passed by your lordships, where my lord, the government order has been quashed by your lordship, confirmed by the division bench. This MUDA, my lord, commissioner is playing truant. He is the one, my lord, who has done all this. He has given an undertaking, not Muda itself. In fact, my lord, there's a resolution subsequently passed saying that, my lord, what he has done is wrong. All that, my lord, they suppress. In fact, my lord, please look at, my lord, page 100 and page 97 of the writ petition.
16
Please have a look at that, my lord. The order passed by the government was set aside by, my lord, the
You should not talk. on that. You have
my lord,
talked
writ
on
petition
that.
comes out covered.
ಅವೆಲ್ಲ
Please come to, my lord, page 91.
Just hold on.
He's paid not to talk.
ಇಲ್ಲಿ ಬರ್ಕೊಬಿಡ್ತೀನಿ. 42, 96.
Shashi, what is that finally you want?
My lord, we'll take a decision, my lord. In fact, the resolution of 1997 itself, my lord, which my learned, assuming your lordship accepts Ravi Shankar's argument in total, my lord, ultimately the ball has to go back to the government because that is what it says. Therefore, my learned friends saying that the commissioner executed sale, allotment, sale deeds, which are all, I mean, I don't want to say it will all be subject to what the government decides. If it decides to accept allotted to it, all will become legal. Otherwise, it will all become illegal. So
Yes.
therefore, my lord, let us take a decision and we'll place it, my lord. Ultimately,
42 sale deeds are already executed. To the extent of 42 sale deeds, title is passed because Muda has executed, the authorized officer of Muda has executed 42 sites. We are the owners of the property.
42 out of
42
not one.
out of 100 and
101.
138 out of 138.
138.
Subsequent resolution to the Muda, my lord, says.
Lords, I will clarify that. I just wanted to clarify that. Lords, what happens?
So, no, 1 minute. So about this, that your decision will have bearing on the.
Absolutely, my lord.
No, your decision will have a bearing on the sites which are already. Sale
Yes,
deeds have been
yes.
executed.
It can't.
Yes.
Yes.
It
The
can't,
reason
my
is
lords.
this, my lords, the basis of this
Can't.
can't will be, that's a different.
Sir, our concern is very simple.
Please, my lord.
Before the MUDA, the deputy commissioner and the commissioner are both quarreling each other
Absolutely, my
for
lord.
their own purposes.
Absolutely.
Still the government is watching and making the court to waste our time.
No, my lord, what the government,
Please take a decision at the earliest.
that is what, my lord, because of the session, we are not able to take decision, my lord.
Then do one thing, if it is having bearing, so ultimately the person, some allottees will have some difficulty about
Please, my lord.
whether the allottee or the, now Mr.
We'll keep
Holla's,
everything in mind and we'll take a decision.
Mr. Holla's client says that he has purchased the property. Mr. Lakshmi Narayan Senior Advocate is saying that he is the owner, the allotment
He's
itself.
taken the money twice over and still is lost.
No, that's right. As we understand.
Land is acquired. It has to be allotted land to the public in accordance with the rules. If you don't want to allot to the public, then whether if you want to allot it, it can only by convey with the government. That is another standard. Two ways are there. And some associations cannot claim as a matter of fact without a paper publication. Muda rectified it by annulling the earlier resolution on the 16th of January 2024. All these resolutions will have to go to the government. My rights also to be adjudicated. That's all, my lord.
As my lords pointed out, we have to solve the problem by taking earliest decision at the earliest and persuading them. A decision has to be taken at the earliest, but
Builders care, if land is acquired, if you are allotting to the private purpose, it is opposed to public policy. Even if the commissioner gives an undertaking, he is giving as my learned rightly
In his
put it,
personal capacity. Yeah.
It is a property of the Muda. Muda
I-
property can only be allotted only with the prior approval of the government if the value is more than 2,000.
ultimately
That's the law.
Lords, may I make one submission, Lords, on behalf of the Commissioner, Lords?
Yes,
On
please.
behalf of the Commissioner, Lord, I am being sought to be projected as somebody who has given
Absolutely.
an undertaking
He is.
without authority of
It's a
law. No,
resolution.
He is.
it is pursuant to a resolution, Lords. I
It's a
said I will
resolution.
implement the resolution.
Lord, that's what I wanted to clarify, my lord. There was a
But
resolution of
pursuant-
23/1/2023 by Muda,
Lords, one
by the
second,
entire
Lord, one
body of,
second.
to which the deputy commissioner was also a party. There was a subsequent ratification which was undertaken in the month of April, to which deputy commissioner
maximum Just a communication. In. I just didn't want, Malad, not later than this, we'll be able to. Oh, this. Well, that is why, Malad, it's not a straight jacket. That is why we need to apply our mind. There are two things.
No, my lord.
Malad.
Even in a contempt, if commissioner files a personal affidavit, he halves the resolution of the court. It cannot be enforceable. If there is a separation of acts, contempt will not lie. Now the allotment is legal or illegal. Now, if it is illegal, then my lord, it can't be enforceable, even in a contempt.
Oh, shit.
That's the first law.
Please. In fact, my lordship pointed out, this decision will be taken at the earliest moment.
This allotment is without a paper notification, without an allotment.
Malad, I can only assure the decision will be taken as communicated at the earliest, Malad.
Internal communication is what he said.
You can record that, Malad. I know. No, not file. Your lordship may make it as orally submitted and.
If some time is granted, government will examine the issue and make further submissions. All right?
Lords,
So-
one other indulgence, my lords. The learned advocate general submitted on 1/2/2024 that there will be no precipitation pursuant to the resolution dated 16/1/2024.
Dated?
16/1/24.
Ah.
Lords, that requires to be extended
All-
till the next date of
all-
hearing.
all. Sri Ravi Shankar, learned senior advocate, submitted that on behalf of the government, the learned advocate general has assured this court on 1/2/2024 that government shall not precipitate the matter as per the pursuant to resolution dated 16/1/2024. Full stop. And this full stop, right? The same may be continued. Full stop. We can. Sri Shashikaran Shetty, in his usual fairness, assures, submits that he has no objection for continuing the said undertaking, ordered accordingly.
Great.
Interim order in WP has to be continued.
Whatever interim orders are there.
Yes, great. Great.
Right.
ಎರಡು ಅವ್ರಿಗೆ ಇವ್ರು ಕೊಟ್ಬಿಡಿ AG ಅವ್ರಿಗೆ
That way is there.
Yes, next.
My lord, after receiving the reply, my learned friend, my lord, we have given fresh proposal to the bank, my lord, I'm ready to, I have already paid 18 lakhs and also paid 28,000.
What is that matter about?
Matter is the honorable.
You have to pay money, is it?
Allah.
Representation. They said the representation was not considered and therefore the contempt.
Now there has been a consideration and it has been duly acknowledged by them. We have
No,
considered the
my lord.
representation. Nothing
My-
remains in
my-
contempt.
my lord,
Now
my-
they say they've given a fresh representation. That will take care of itself, my lord. So that has nothing to do with the contempt. Contempt is to be complied with, my lord.
My lord.
My lord, ಮೂವತ್ತಿನ ಬಂದಿಲ್ಲ ಅನ್ಸುತ್ತೆ. ಮೂವತ್ತು.
Absent Shri Kumar for.
My lord, my lord,
Yes.
myself, Shobha C. Party in person, my lord.
What is the compliance? What is the non-compliance, madam?
My lord, I have filed the rejoinder, my lord, on 17/2, my lord.
No, no, any violation? No, if you have to be argued, you argue on some other date. Submits that she has filed a rejoinder for call on such and such date. Yes, Pawan Shetty.
ಆಯ್ತು 31, 32, 30.
My lord.
You argue, thank you.
In 33, my lord, without telling us, I'm told a motion was made. There's some urgency, my lord. There's a time-bound compliance that I am
That is why that we gave some aspirate for that.
Indeed, we have approached the respondent partner, your lordship, the company partner. And he was not well, your lordship, so he also sought the time, your lordship. We are in talks with the.
So no problem. Deposit the money with the Registrar General. He will not get it. First, your deposit must come in COMAP.
Your lordship, we are ready to deposit, your lordship.
Please do that.
Then a stay may be also granted, your lordship.
Of course, we'll grant stay. If you deposit, we'll grant stay.
We are ready to deposit 25%, your lordship.
No. Those are poor workers. And there's a, what is it? They're guards, security guard.
This is
Security
the
guards,
company which is
housekeeping.
providing the services, your lordship. It's not the security guards with whom
Look,
the.
Madam, please don't make such submissions and are dismissed.
No, your lordship, we'll deposit, your lordship. Otherwise, matter may be passed over, your lordship.
We'll pass it over to you.
ಪಾರ್ಟ್ನರ್ಸ್ ಹತ್ರ ನೀವು ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ ಇಲ್ಲೇನೆ ನಾನು ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀನಿ, your lordship. I'm ready to deposit 30% also.
No, madam, they must get, you see, the security guards are the poorest class here.
Yes, your lordship.
They'll be standing overnight from 24 hours duty they do. How will the companies survive if you don't pay them the money?
I'll deposit.
Compare yourself with that. You see, you are running huge businesses and for the security people.
I'm ready to deposit 30%,
No, madam, sorry.
your lordship.
We are not inclined.
Then matter may be kindly passed over, your lordship.
Pass over, all right.
Matter may be connected, serial number 61, my lord.
You are appellant?
For appellant.
You are the appellant? Yes, maybe called in 61.
61 along with 61.
Along with 61.
Please.
Date ಹೋಗಿದೆ 61 date ಹೋಗಿದೆ.
Yes.
Hello, serial number 48, IN number 2 may be dismissed as having become infructuous, my lord.
Yeah,
An
deposit.
SLP was filed. The order has been set aside and remanded to this honorable court to be heard on 1/3. My lords, the SLP was on Friday, my lords. We don't have the order as yet.
My lord, I'm producing a copy of the order.
So it's been, which
24 to deposit to furnish security for 15 odd crores has been set aside by the Supreme Court, my lord.
Right.
And the matter is remanded for fresh hearing on
For
1/3.
fresh consideration.
advocates.
IA2 was originally filed by me for exception.
That's all right. Now it's
Maybe
not there. Learned advocates on both sides submit that IA2 of 24 does not survive for consideration, dismissed.
My lords, your lordships may have it on 1/3, my lords.
1/3, my
That's the
lord. It's
date
been
given by
directed by the
the.
All
Honorable
right,
Supreme Court. I'm filing the order copy. as well.
Non-furnishing of security, then it doesn't arise. They also submit that
My lord, if
the
you
office
need-
note regarding furnishing of
Want to delete.
submit that office note 1 and 2 do not survive for consideration in view of order passed by the Supreme Court. Full stop. Call on, as prayed for, call on 1/3.
Grateful.
Next.
Appearing to the government, my lord.
For the appellant, my lord, though the matter has come up for preliminary hearing, there is a delay. My request to your lordship is kindly order notice on IA1.
This
What
is
is
a challenge to an acquisition which is of the year 1968 and 71. Government order which is of the year 1979, my lord.
So file your objections
And
today.
this, the learned single judge has dismissed this, stating that the ownership itself was questionable in OS 1774, which is decided in the year 1999.
Section 11 of CPC, no particular litigations.
And they have challenged the acquisition dated
What is, there appears to be a joint memo in that.
Please, my lord,
withdrawal, yes.
my lord, may I just submit, my lord, since your lordships were busy, I thought I'll not take your lordship. My lord, an extent of 4 acres, 20 guntas was acquired.
And the dispute now is relatable only to 20 guntas of land. In the earlier round of litigation, my lord, the petitioners, the appellants herein and the society concerned filed a joint memo saying that no, they don't have any claim over 20 guntas of land. However, my lord, without passing orders on that, the writ petition was dismissed as infractuous. Thereafter, writ appeal was filed and the writ petition was withdrawn. And this is the second round of litigation. My lord, the only question is whether, my lord, abandonment by the BDA. There are two endorsements given by the BDA. They have not taken position, which is annexure Q and R. They are the necessary parties and the society is the necessary party. That's why, my lord, since there is a delay, my request to your lordship is notice on IA1 may be ordered.
My lord, just
Please.
a moment, if your lordship could just see for a moment, there was a OS that is at page 152, annexure P. That was relating to the title of the appellant's herein versus the
See,
society.
Madam, you are only government.
Please, please,
There are
please.
contentious, there could be contentious issues, QA, PDA and that society.
Please.
So let them say something, then at that point, we are not admitting the matter.
One is about delay and whether the appellants herein have the locus standi to challenge that acquisition proceeding itself is questionable.
Fair
because
enough.
of
Let
the
us see.
OS.
Notice, learned GA accepts notice for 1, notice to 2 and 3.
Please.
Much obliged.
I appear for the petitioner.
Anirudh?
I appear for the petitioner.
Yes.
This was heard last week.
Sorry?
Your lordship adjourned by saying contentious issues are involved.
Mahendra respond straight for deemed extension. Oh, yes, that deemed extension, is it?
Deemed extension.
What is to be done? Matter requires hearing?
Yes.
Matter has to be heard, then please take a date of your convenience, sir.
7th or 8th March.
All.
it can be.
8th. Yes, please.
This is a case where I have been asked to pay 5 lakh rupees to the respondent, even though there is no employer and employer relationship. Madam, the appellant is a state public sector industry. I had entered into contract with Kianix, which is also a state public sector industry for supply of manpower, my lord. Respondent was engaged through Kianix. But after she was disengaged, my lord, she has raised she has filed application on section 10.40 of IDA Act. Now she is working with Kianix only, my lord.
All right, notice 85 days delay is there.
ಅಲ್ಲಿ coercive steps ತಗೊಂಡಿದ್ದಾರೆ ಶೋಕಾಸ್ ನೋಟಿಸ್
Hand delivery ತಗೊಳ್ತೀರಾ? Hand summons permit ಮಾಡೋಣ?
ಅಟ್ಲೀಸ್ಟ್ coercive steps
ಹೆಂಗ್ ಮಾಡೋದು ಹೇಳಿ? ಅದು ಎದುರುಗಡೆ ಯಾರು ಇರೋದು? ಪ್ರೈವೇಟ್ ಪಾರ್ಟಿ ಅಲ್ವಾ?
Yes, ನಾಯಕ್.
Private party. She has to get money. Then how can we?
ಒಂದು ಅಬ್ಸರ್ವೇಷನ್ coercive steps ಏನಾಗಿದೆ ಅದೊಂದು ಮಾತ್ರ ಇದೆ.
How can we do that? The amounts to stay alva. Please serve a copy. Hand summons permitted.
Hand summons. Much appreciated.
Yes.
My lords, 52 with their deepest apologies, my lords. It was listed today, my lords, only at the request of us that there is serious urgency and the senior counsel was also there. Without informing us, they have taken time and gone, my lords, at 10:30.
What do we do, sir? If
No, my lords, I'm
advocates
only-
come and then say something, then we'll have to accept their.
I'm only expressing my,
Who is appearing on the other side?
my lords may have it tomorrow because
sir.
no, D.R. Ravi Shankar is the senior counsel engaged, my lords, Mr.
Both of
Vasant
them-
Madhava.
Vasanta Madhav and D.R. Ravi Shankar, both were there.
Both of them have not informed us, my lords. Even before or after. No, my lords,
Please
they
talk
have,
to
they are now enjoying
Sir,
an
why do
item
you want
order.
us to spend time on this, If lawyers don't.
My lords, if
follow
tomorrow
the
at least, my lords.
No, sir, please understand, tomorrow we have 100 matters. Where do we add these cases?
Well, this was listed today only so that my lords had heard us on
We'll
urgency.
hear it, we'll post it tomorrow. Then do what? Is it possible to take up the matter and dispose of? Even if we write, we have to write the orders.
My lords,
We have 2 days.
I understand, my lords, but my anguish is,
Don't we'll give a late, it's a shorter date, that's a different matter.
my lords,
ಯಾವ- ಯಾವ
my
side of-
anguish is they're enjoying an interim order, vacating stay applications are pending.
Then please move it next week. That's the only thing that we can suggest to you.
My lords, it's a conduct of the parties which we are espousing before the court, my lords. Dilatory tactics, my lords, only meant to avoid hearing. After enjoying an interim order.
ಮೋಷನ್ ಟೈಮ್ ಅಲ್ಲಿ ಯು ಶುಡ್ ಪ್ರೆಸೆಂಟ್ ಇಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡೋದು ಈ ತರ ಆಗ್ತದೆ.
ಅಲ್ಲ ಅವ್ರು ಹೇಳಿದ್ರೆ ನಾನು
Why are we getting into dialogue on this, Mr. Patil? How many times we must explain to you?
Lords, in this matter, I appear for appellants, my lord. There is a delay of 42 days, my lord.
What is the matter about?
Matter, my lord, the respondent number 6 herein has claimed Kata in respect of his alleged property
What is the
bearing.
impugned order, sir?
My lord, impugned order, my lord, I have also filed a writ petition before both the matters came up before the learned single judge. My writ petition allowed, my lord, I may permitted to produce
Civil
this
codes.
in respect Kata. There are 2 writ petitions filed by us. I filed writ petition, my petition was allowed. And his writ petition, the respondent number 6 writ petition, adjourned on the ground that he has not produced the Kata standing in the name of his father or their vendor. Well, kindly peruse.
No, but now, yes, we'll see that. But now, the final order is that
This
relegating.
order runs contrary to the order, earlier order passed in my favor.
Sorry?
That's the reason.
Please give. What is the order passed?
But both of us are admittedly claiming one and the same property.
Right.
His claim is his property.
Please show which is there, which is contrary to that, contrary and
Kindly,
theater.
yes. Kindly peruse para 7, man, internal page 8. While petitioner, in the middle, while the petitioner claims that the property bearing new Kata number, condition 67 was owned and possessed by his father, the respondent number 4 claims that the property bearing condition 14 and Kata number 136
All
was
right,
owned.
correct, you are right.
Notice. But this runs contrary, but
Yeah,
I'm
you should
seeking
notice, sir.
interim stable.
42 days delay is there.
Allowed at least notice for respondents one day.
All right. GA accepts notice for 192, notice to 3. Gurdev.
Yes, my lords. The learned single judge, my lords, has dismissed my petition. Lords, though, my lords, the corporation itself says, my lord, that we have.
What? Your petition is for what?
My lords, there was a contract, my lords, certain amount of money not having been paid, my lords. Well, it's nobody's case, my lord, that have not done, my lords, the job. It's the only thing, my lords, though the corporation itself writes to the government, saying that in the interest of public, they have indeed maintained the street lights and they have sought the permission to pay, my lords.
But when money has to be given, there must be some kind of fact finding.
ಅಲ್ಲ ಅವ್ರು ಒಪ್ಕೋತಾರೆ the corporation which is the,
ನಮ್ಗೆ ಎಷ್ಟು ದುಡ್ಡು ಕೊಡ್ಬೇಕು ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಅದನ್ನ
it's not disputed, my lord. In fact, G may kindly be seen, my lord. In fact, my lords, the corporation itself, the agency which has given me the contract, writes to the government that in terms of the variation clause, my lord, the petitioner has done the job and they seek the permission to make the payment.
Recovery of suit commercial court case
ಅಲ್ಲ, my lord, in fact, my lord, the point is well taken. The Honorable Supreme Court.
without paying court fee, you can't.
The Honorable Supreme Court says just because it's the matter of contract, the petitioner cannot be non-suited. But it is not a case where there's a dispute, my lord, the government agency itself agrees.
At the same time, writ also cannot be issued. If there are issues with
My lord.
regard to who has, if it's a recovery of money.
Please, my lord.
As my lord just now told you, the commercial court is the.
My lord, if you tell my lord, my work was disputed or my lord, they were saying that I have not done the work, it was a dispute question of fact. But the agency itself says that I have done the work, my lords. And I said, in fact, my lord, even they write to them, there is a variation clause.
Ink page 22.
Please, my lord. The reasoning, my lords, may kindly see, my lord. At para 6, my lord, page number 20, my lord.
Sir, it is a issue regarding tender work.
Please, my lord.
The dispute is financial monetary issue ಇದೆ.
ಅದನ್ನ ನೀವು ಅಲ್ಲಿ ರಿಕವರಿಗೆ ಹಾಕೋಬೇಕು.
ಅಲ್ಲ ಅಂದ್ರೆ if it was a dispute of me having done the work, my lord, it's undisputed that I've done the work. In fact, Annex G, the corporation itself is on record. They returned to the government. So may I, my lord, the delay, my lord, may I seek, my lord?
Page.
No, Annex G 66 to 68, my lord. For 68, my lord, may kindly take, my lords. ಹೆಚ್ಚುವರಿಯಾಗಿರುವ ಬೀದಿ ದೀಪಗಳಿಗೆ ಸಾರ್ವಜನಿಕ ಹಿತದೃಷ್ಟಿಯಿಂದ ಗುತ್ತಿಗೆದಾರರು, that is me, my lord. The petitioner need not be non-suited anta, my lord, as far as my 2023 judgment also.
No, that's a different matter. Page 68, what do you want us to say?
My lord, 68, my lords, the corporation itself writes to the government. I may be permitted to read, my lord. Unnumbered paragraph 2, after the table at page number 68, my lord. ಹೆಚ್ಚುವರಿಯಾಗಿರುವ, I'm able to point out, my lord. ಹೆಚ್ಚುವರಿಯಾಗಿರುವ ಬೀದಿ ದೀಪಗಳಿಗೆ ಸಾರ್ವಜನಿಕ ಹಿತದೃಷ್ಟಿಯಿಂದ ಗುತ್ತಿಗೆದಾರರು ಚಾಲನೆ ಮತ್ತು ನಿರ್ವಹಣೆ ಕೈಗೊಂಡಿರುತ್ತಾರೆ. ಶೆಡ್ಯೂಲ್ ಬಿ ಯಲ್ಲಿನ ಬೀದಿ ದೀಪಗಳ ಸಂಖ್ಯೆಗಿಂತ ವಾಸ್ತವವಾಗಿ ಶೇಕಡ 42.95 ರಷ್ಟು ಅಂದರೆ ಸೋ ಅಂಡ್ ಸೋ ಬೀದಿ ದೀಪಗಳು ಹೆಚ್ಚಾಗಿರುತ್ತವೆ. ಹೆಚ್ಚುವರಿಯಾಗಿ ನಿರ್ವಹಿಸಿದ ಬೀದಿ ದೀಪಗಳಿಗೆ ಶೆಡ್ಯೂಲ್ ಬಿ ದರದಂತೆ ಪ್ರತಿ ಮಾಹ ಹೆಚ್ಚುವರಿ ರೂಪಾಯಿ ಸೋ ಅಂಡ್ ಸೋ ಗಳಂತೆ ಕಾರ್ಯಾದೇಶದ ಕೊನೆಯ ದಿನಾಂಕ ಪಾವತಿಸಬೇಕಾಗಿರುತ್ತದೆ. This is what, my lords, the corporation itself at whose behest have done the work right to the government, my lord.
Is there any statement anywhere written by the corporation saying that we owe so much of money?
Well, this is, my lord, this letter written by them where they say we have to,
Quantification, sir.
sir, they say we have to pay anta ಹೇಳ್ತಾರೆ. We have to.
Correct. How much?
My lord, it is, my lord, 2,60,720 per month, my lords. The last line of that unnumbered paragraph, my lord, may kindly take. 2,60,720 per month. The undisputed amount, my lord.
Not undisputed, sir. Please show it that it is undisputed from some record.
But Annexure G, my lords, and Annexure F also, my lords, may kindly take, my lord. Annexure G, in fact, my lords, a letter written to the government. And once, my lord, the government says, you take a decision at the corporation level itself, my lord.
What have they said? That we owe so much of money to such and such and we have to pay ಅಂತ ಎಲ್ಲರೂ ಬರ್ತಿದ್ದಾರೆ.
They seek the permission to pay, my lord.
ಎಲ್ಲಿದೆ ತೋರ್ಸಿ.
Lord, ಸದರಿ ಮೊತ್ತ ಮೇಲಿದೆ ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್, my lord, of page number 60. ಸದರಿ ಮೊತ್ತವನ್ನು ಪಾವತಿಸಲು ಅನುಮೋದನೆ ಕೋರಿ ಪೌರಾಡಳಿತ ನಿರ್ದೇಶನಾಲಯಕ್ಕೆ, so they have sought the permission to pay, my lords.
My lord, may I make one submission? My lord, the contract was for the period 16/9/2019 to 15/9/2020. My lord, for that period, my lord, the amount has been paid. My lord, there was now for an extra period, my lord, he has done the maintenance work. And for that, my lord, he seeks for this amount of 31,28,000, for which there is nothing on record.
But the very letter written by my
lord.
Right.
Liberty is reserved to the appellant, my lord, to avail appropriate remedy.
Oh, it's variation in the quantity of work. Paraten Budia.
Please, my
Over
lord.
the contention, this is contention.
It is not in dispute that the petitioner has been paid the amount as per the tender document. The present claims only in respect of the alleged variation. The alleged Swami. They themselves say that there is a variation clause. They refer to the variation clause, please, my lord. And they say in public interest, I have done it, my lord. In the public interest, I have done, my lord. So they're not, my lord, I can understand they're disputing that I have done the work, my lord. No, at least for notice, my lords, I'll be able to persuade, my lords. Public work ಮಾಡ್ಬಿಟ್ಟು in the public interest ಮಾಡ್ಬಿಟ್ಟು, my lords, again I have to run from pillar to post to get my.
Paraten in the we cannot issue even notice also. See, as per the tender document, amount has been paid. End
Please,
of the
my lord.
matter.
But Annexure C, my learned senior friend is saying that there's no document on record to show that the municipality has permitted me to work after the period.
That's all right. They have
Annexure C
permitted.
kindly be seen, my lord.
The question is whether as per the tender document, payment has been made. Now some extra money has to be paid. There is
The
no quantification.
variation clause is also as per the agreement itself, my lord.
Please show us that we owe so much of money. That quantification is there, we'll consider, not otherwise. Compare.
Only per month ಅಂತ ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಹೆಂಗಿದೆ?
Only per month ಅಂತ
ನೀವು
ಹಾಕಿದ್ದಾರೆ.
ಎಷ್ಟು ತಿಂಗಳು ಮಾಡಿದ್ದೀರಾ?
Lords, But in annexure F may kindly be seen, my lords.
ಇದು ನಾವು ಇಲ್ಲಿ ಎಕ್ಸಾಮಿನ್ ಮಾಡಕ್ಕಾಗತ್ತ
Only one line may lords may permit it, sir. No, only one line may lords may permit, my lord. Annexure F, my lords. Annexure F nalli.
With interest, everything you will get it there.
Only annexure F, only one line. I'll not, I board on, my lord, only one line, my lords. Annexure F at page number 63, my lord.
Yes.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ ಪತ್ರದಲ್ಲಿ ತಿಳಿಸಿರುವಂತೆ ಶಿವಮೊಗ್ಗ ಮಹಾನಗರ ಪಾಲಿಕೆಯು ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬೀದಿ ದೀಪಗಳ ನಿರ್ವಹಣೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಪ್ಯಾಕೇಜ್ ವ್ಯಾಪ್ತಿಗೆ ಒಳಪಡುವ ಹೆಚ್ಚುವರಿಯಾಗಿ ನಿರ್ವಹಿಸಲ್ಪಟ್ಟಿರುವ ಬೀದಿ ದೀಪಗಳಿಗೆ ವ್ಯತ್ಯಾಸದ ಮೊತ್ತವಾದ rupees 31,28,640. Then this is exactly what I am claiming, my lords. This is a response of the DMA, my lord.
ಅವರು ಕೊಡಲ್ಲ ಅಂತ ಅಜಿಟೇಟ್ ಮಾಡ್ತಾ ಇದಾರಲ್ವಾ ರಿಟ್ಟಲ್ಲಿ. Saying you are right. So
If
go and urge,
it was denied to me on the ground that you have not done the work, my lord, I would have gone, my lord. This is the difficulties. I have done the work, my lord, and even the respond number 2 says that you take action to pay.
Correct.
Corporation is not considering your claim.
Government is not
They-
entitled to pay. You have not done.
See, they're not standing by either 1121 letter.
But their own letter, my lords. Right?
So if they don't stand by, can we force them to pay based on this? Saral.
Please.
But already reserved, they can.
Other. Prayer in the writ petition was to direct respondent number 3 to pay a sum of rupees 33,89,369 along with interest. Full stop. Honorable single judge has recorded in para 10 of the impugned order that petitioner has been paid the amount as per tender document. The present claim is with regard to the alleged variation,
In the quantity
and
of.
that the present claim is in respect of the alleged variation in the quantity of work carried on by the petitioner and relegated the party to the and held that
Liberty reserved for him.
and held that the writ petition
Now, my lords, if,
like what Mr. Nair argued, the same matter, is it?
my lords, the same matter, my lords, previously Mr. Nair had argued. My lords, the only reason,
But same matter, why you are arguing?
my lords, the previous one was a different matter, my lords.
My lords, this matter is already covered by the Constitution Bench decision in DS Nakara, my lords. Learned single judge has followed that and passed the order. The appellant before your lordships did not even contest the matter. No statement of objections was filed. There is a cutoff date for family pension liberalization. All those who died before 1/7/2005 are not entitled according to the
1/7/2005?
Thereafter, there is a 30% enhancement. The original petitioners before the learned single judge are widows of persons who retired before 1/7/2005.
Retired or died?
Retired, my lords, both retired and died, they are not entitled.
That's a cutoff date.
Please, my lords, that by the judgment of the Honorable Supreme Court and DS Nakara, cutoff date has already been held to be unconstitutional. Following that, my lords, the learned single judge has allowed the writ petition. Now, the KBC.
Stating what?
My lords,
Well, that the cutoff date is arbitrary and does not have any nexus. My lords, for family pension, how can it be that there can be a cutoff date because those people are also earning family pension, my lords? The respondents whom I represent are getting nearly 2,000 rupees only, my lords. And the others have a 30% enhancement, which they say they are not entitled.
My lords, if I could point out in the
But
They did not
kindly,
contest the
kindly
matter.
listen that you did not contest the matter.
No, they did
Please,
not.
my lords. My lords,
How can you come and then argue matters here? You file a review there.
my lords, insofar as the impugned judgment itself is concerned, my lords,
Please
in-
see, Mr. Young Advocate, if you are not gone before the Honorable Single Judge, not argued the matter, how can you come and say that his judgment is wrong?
my lords, we do admit that before the learned single
When we
judge, my
ask a
lords,
question, you must kindly answer that question. There's an Honorable Judge sitting there, hearing the parties, passing an order. You don't go to the court. You don't participate in the proceeding. Come here in the appellate bench and then say that, no, this has happened, that is. If you want, file a review.
my lords, we had appeared before the learned single judge. There was no statement of objection that was filed. Now, in respect of the learned single judge's impugned judgment, my lords, we have only one submission, that the learned single judge at page 31, my lords, he states.
Sir, you don't file your statement of objections. You don't contest the matter. Then how we have to declare that the judgment is wrong? If you want, file a review petition, no problem, we'll grant you liberty.
My lords, I have one submission, my lords. My lords, these women are all widows, my lords. Kindly see the date of the judgment.
What have we done?
My lords,
We have
I
not
had
passed
suc-
any order.
My lords, I had succeeded. There was a time limit.
Madam, why are you spending your time? We are not interfering nor passing any order.
My lords, there was a time, my lords, I'm only explaining my predicament, my lords. There was a time limit.
For
within
what
which-
reason?
My lords, I'm not
Fair-
receiving the pension, my
Fair
lords.
enough, but the point is, can we do something now?
My lords, your lordships may kindly dismiss the appeal, my lords.
Then what else were we trying to say?
Very well. My lords, I'm only opposing the liberty for review, my lords.
See, whether we say or not, he may have a liberty. That's a different matter.
My lords, after filing an appeal, unless you all
My lords,
give
if-
liberty, he can't file a review.
My lords, insofar as the instructions on why we did not submit a statement of objection, my lords, if I could just seek a very short adjournment, my lords. I will need to seek instructions because on the basis of which all of the grounds that we've raised in this appeal, my lords, will become relevant. And my lords, insofar as why the
Sir,
specific
our
reasons for
question is more fundamental. That the party who does not contest a matter, does not say anything before the Honorable Single Judge, comes and says that that judgment is wrong. Do what you like, all right, he wants 1 week's time. Makes
My
sense.
lords,
My
this
lords,
is the
please.
third or fourth time they're taking time, my lords.
my lords,
In fact, your lordships had in fact indicated, find out the number of people who will be affected by this order and if it
Oh,
can be
yes,
paid.
for financial
Please, my lords.
burden. Yes,
That
how many
also has
people,
not
correct?
been done.
Please, my lords, we have, and my lords, it is.
What is the financial burden on you, Mr.?
My lords, there are a number of related family pensioners, my lords. This is upwards of 2,000, my lords. We will file a affidavit with exactly the number of affected family pensioners as well as instruction on this point, my lords. Just a short accommodation.
My lords, it's already.
Did we anytime ask you to let us know how much is the financial?
Please, my lords, in a previous order before a coordinate bench, on that ground, time was taken by them.
Are affected and in
But now implication, now we have made the calculation.
Please, my lords, we have the number of pensioners, the exact financial burden, my lords, we'll need to file a detailed affidavit. We'll provide all of the details in that.
Then what were you doing? All these days we have given you time for that.
No, my lords, we have, they have only provided us with the number of pensioners. However, the exact financial burden, they have not
are
been
you?
able to calculate and tell us so
So
far.
KPC.
No, just a very
You,
small.
you have an army of people to do that.
Please, my lords.
Yes,
My lords, I
then-
apologize. Just a small accommodation. We will ensure that the entire financial burden is placed before this court.
Go find out how much how much will be the financial burden, come back and tell us, we'll accordingly dismiss the appeal based on the quantum. If it's a small quantum, we'll not interfere.
My
Go
lords,
find out, mister.
my lords, it will take us some time, my lords, because this is there'll be a number of family pensioners and we are given to understand this is upwards of 2,000 family pensioners, my lords. Now, just a short accommodation, we can provide all of these details in a detailed affidavit.
All right, take it next. Learned advocate for the appellant. On the last date of hearing, we had called upon the learned advocate for the appellant to submit with regard to the financial burden that appellant may be exposed to, Time, call next week or something.
It's very good.
Give a date. Yes,
My lord, I am for the appellant, my lord.
yes, madam,
Due to some personal inconvenience, my senior is not there, ma'am.
not well.
So kindly,
Learned advocate seeks time, call on such date. Yes,
My lord, in this, I appear for the respondent.
yes.
My lord, I had, by order dated 25th July 2023, I had directed to place before your lordship the record pertaining to the revenue documents, my lord, relating to this survey number. My lord, I pray for 2 weeks' time.
I represent the appellant. This is the case where the sub-registrar has cancelled the registered sale deed 6 months after the registration of the sale deed on the ground that it was a Goma land. So that is the reason, Your Lordship kindly
They have
say,
to produce the papers.
yes, regarding the nature of the property and fairly they have to produce.
All right.
Lord's
Learned
one
GA
submission
seeks 2
insofar
weeks
as
time
the
to-
connected matter, may I intervene? The connected matter, Lords, is filed by me, who are the purchasers of certain sites in the very same land. They have constructed houses. Now, Lord, since they were not parties before the writ court, they have filed this
Fair
appeal
enough, but
by
once you-
seeking permission.
you'll
Lords,
tag
I'm not
along.
opposing granting time. My only endeavor is, Lords, if there can be an interim order in the connected matter also.
For
Because
what?
I have constructed houses, we are residing there.
What is
we
the
are a site
interim
purchase-
order in
There is an
57?
interim order granted in the other case.
In 57, what is the interim order?
Lords, the interim order is, Lords, the stay of the learned single judge's order, as well as, Lords, neither party shall not attempt to alter the nature of the property.
Fair enough.
It's, if it can be extended to my writ petition, since the very same order is challenged by the site purchaser.
your-
Notice of.
This
Who are
delay
the-
of 6
who are the
days.
respondents?
Lords, respondents,
Vendors,
Connected
GA,
798.
legal heirs of the vendors.
1 minute. But in any event, this will cover you. You're claiming title under the, appellant in 4747.
under the appellant, that's true, Lords.
That's
But
it.
what the problem is, Lords, if there is no stay, Lords, the respondents who are vendors of the appellant, Lords, they are threatening me and
Oh, there are so many where you will have to serve them.
Mr. Nanjareddy is appearing for them, Lord. He's
The
appeared in the
appearing, you see,
connected matter also.
District Registrar, Sub-Registrar, Inspector General, GA will take notice. What about 4 to 12?
4 to 12 are represented
appearing
by
for
Mr.
4 to 12.
Nanjareddy, Lords.
All 4 to 12. So you take notice for them.
No.
Lords, not.
First case.
No. If they are represented, it can't be done like that because that's a different list, this is a different
Yes, I will
list.
take notice. No, but either. Okay, I will take notice.
To Shantamma, Suman, all those people.
Yes.
ನೋಡಿದಿರಾ ಅದರಲ್ಲಿ ಸ್ವಲ್ಪ ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ.
ಹೌದು. Lords, insofar as.
1 minute, let him just say. 4 to 12.
Shantamma, Suman, Ushmita.
4 to 12 ಅಲ್ಲ.
4 to 6 ನೀವು ತಗೋತೀರಾ.
4 to 6 one. They are the appellants in my case.
Then 7 to 12.
7 to 12, Mr. Nanjareddy, I may be permitted, so I'm not.
All right.
The 7 to 12 are the petitioners in the writ
All
petition.
right, 1 minute. GA accepts notice for 1 to 3. Mr. So-and-so accepts notice for 4 to 6, is it?
6.
Yes, yes. Sure.
As spread for notice to 7 to 12, as spread for by learned advocate for the petition appellant. Appellant is permitted to take out notice on Sri
Nanjareddy,
who
is appearing in the connected matter.
appearing for the said respondents in the connected matter. Office to show his name.
Very.
Madam, may extend it.
In 798. 798 ಅಲ್ಲಿ interim order. 747.
747 ಅಲ್ಲಿ interim order.
All right, 747 interim order. Next. Yes, please. Yes.
So in this matter, the applicant filed under section 33A, my lord. for the violation of and the learned judge proceeds on the basis of it is a matter under 33. Notice already they have been served.
Notice is already there. What do you say for delay?
Delay.
No objection. Has no Renuka has no objection. I have an allowed delay condoned, admit.
Please, Milord.
Yes.
I am before Lordship and in the order passed by the OA, original application. The surpassive proceedings and the RDB Act are they both parallel
You are
proceedings?
borrower, is it?
Yes, I am the borrower, my lord.
File a petition under 17.
No, 17 also we have filed, that got dismissed, and 13.4 which are challenged. But section 14, when they wanted to take the physical position,
Section 17, if it is dismissed, you must go to DR80.
no, 13.4, that is challenge. But in the meantime, bank wanted to take physical position under section 14, my lord. I may permit take only 219 pages, my lord. Only one paragraph, my lord, 219 pages, my 219, my 219. I may permit, my lord?
Yes.
Yes. The plain reading of the above said provision clearly establishes that all the facilities granted by the bank to the borrower and investment in all the securities issued by the borrower will have to treat it as NPA and not the particular facility, but not facility wise. In other words, the petitioner bank has bifurcated two loan transactions in respect of both firms, though the proprietor and guarantor of both firms are one and the same, under which transaction classified those grounds as NPA on different dates, which is not permissible under the law. It means it is contrary to the section 2O of the Act. This has been classified. My account does not fit into section 2O. That is a contrary. Then further, therefore, in view of the above discussions and reasoning, I am of the opinion that there is sufficient material on record to
Sir,
establish.
this was the subject matter before the DRT under 17.
No. This is under section 14, the order, ministerial order. Though it is order has been passed, dismissing their petition, the bank filed one more petition under section 14, second time. That I challenge before the criminal revision petition. That also dismissed. Before the Honorable High Court, again I challenge. That Honorable High Court order granted interim order of stay because it amounts to res judicata. When matter thus stands, the bank immediately did not opt to further proceed in surpass yet, but they proceeded as original application. Through recovery officer, they conducted the auction when the matter is pending.
DRT was also pending. is it?
Our OA is pending. Then OA was allowed.
OA
when I
was-
challenged before your lordship, the permission was given to us to agitate before OA.
So the bank filed an OA.
Two OAs up to 89.
So
830, yes.
OAs have been allowed.
Yes, OA has been allowed.
If OA has been allowed, what is the remedy?
I had to approach the DRAT under section 19. But here, your lordship, when my account does not fall under the category of NPA at all, my very classification NPA does not, is contrary to section 2O. When surpass yet not is applicable,
For all practical purposes.
my lord.
SURFACE Act has become redundant in view of the order passed by the OA.
No, in original application, though I have filed my rejoinder, it was not considered. The court has given me order to file the rejoinder there. I filed rejoinder and the rejoinder dismissed
We
by
will
the
ask you
DRT.
again.
Your lordship.
We'll ask you again.
Yes, my lord.
You borrowed money from the bank.
Yes, my lord.
Bank initiated OA proceedings before DRT. Those OAs have been allowed. Pursuant to which sale has taken place?
Yes, my lord.
Pursuant to which that recovery officer has initiated and sold the property.
Yes.
So what do you want now?
Now here, my lord, when one order is interim order of status is granted by this court with regard to section 14 not to take possession of the property, on the same cause of action, recovery officer, can it take the possession of this property when the interim order of stays in
What
force?
about the decree in OA, sir?
OA is recovery certificate. Based on the recovery certificate, recovery officer has conducted the auction on the
Correct.
same property. Then when the stigma is there, section 14, when the order is,
Just saying for a moment, SU SURFACE Act.
yes, my lord.
What is the substantive provision? OA.
Original application when is allowed, I have to prefer appeal before DRAT.
So OA ನಲ್ಲಿ ಡಿಗ್ರಿ ಆದ್ರೆ
Yes.
ರಿಕವರಿ ಮಾಡ್ಕೋಬಹುದಲ್ವಾ?
Andre, unless this,
Forget about surfacing for a minute. We have been asking you 3 times.
yes, my lord.
If there is somebody borrows money,
Yes, my lord.
right royal method is to file an OA,
Yes, my lord.
recover the money.
Yes, my lord.
Bank has done it.
Yes.
So what else can be done?
In, when the OA was pending, my lord, my submission, when I filed rejoinder, based on the direction given by this court, my rejoinder was dismissed
Tell in the DRAT.
and the OA is allowed.
Correct. So you must say, that is according to you that OA was wrongly allowed. Correct. So if a order passed by the DRT is wrong, what is to be done?
I have to prefer appeal before the DRT.
That.
When same principle, if you adopted in the surface yet, when this order is passed by my lordship,
In substance, undisputed facts of the case are petition, appellant petition, writ petitioner is the borrower of, has borrowed money from which bank?
this Canara Bank, respondent bank.
Canara Bank. Canara Bank has initiated proceedings under OA, under proceedings before the DRT in OA number
OA 829 and 830.
822 of
829,
829
2017
and
and 830 of 2017.
830 of 2017. OAs have been decreed. Pursuant thereto, the mortgage property has been auctioned. One property or many property?
One property, they have conducted the auction. That
Property.
auction I have challenged before the single bench is pending adjudication.
Where you are challenging?
Yes, man, it is in the, it is pending adjudication before this London single bench, your lord, in the number 7940 of 2023.
Or
7940.
learned advocate submits that the sale conducted by the recovery officer is challenged in WP number
40
40 of
2023.
40 of 2023. The instant writ petition was filed. ಅಲ್ಲ ಮೊದಲು writ petition ಯಾಕೆ? Passed in OA 829 of 2017 and 830 of 2017 in the instant writ petition. Full stop. The Honorable Single Judge, having considered the matter in extenso, has rejected the writ petitions and reserving liberty to approach the DRAT. Full stop. The settled position with regard to remedy against an order passed by the DRT on an OA filed under section OA ಯಾವ್ದ್ರಲ್ಲಿ ಹಾಕೋದು section?
Section RDB Act ಅಲ್ಲಿ. RDB Act 19, section 19.
Section 19 of the Recovery of Debts Act. ಅದೊಂದಿದೆ ಕೊಡಿ ಮತ್ತೆ DRT Act. Recovery of Debt, etc. Act. Full stop is to prefer an appeal under section
20, about 20 ಬರುತ್ತೆ.
20. Section 20 before the DRT. We are at one with the, we have taken by the Honorable Single Judge, appeal fails, dismiss, no cause.
Your Lordship, one submission, my lord.
ಹೇಳಿ.
Lordship. ಈ writ petition ಅಲ್ಲಿ section 14 ನಲ್ಲಿ, when they have suffered an order, is a common order, then bank also should have preferred appeal before the DRT.
Sir, if you
Under
don't
section-
touch Surface Act, what happens?
But it's complementary to each other.
Case is over. Thank you. Surface is only additional.
Additional and parallel.
Not challenging the order of the authority. The issue was, my lords, about the approval of promotion which was granted to the private respondent therein. That was quashed by the.
What
Learned
is the
Single
order
Judge.
given by, in the,
My lord, the Learned Single Judge, my lords, while quashing the promotion which was granted, If lordships kindly come to my lords, annexure D, my lords, page number
What
40.
is the violation?
My lords, there was direction, my lords, to consider my case within 3 months. It has not been done.
To do what?
Page number 52, my lords. That is,
What did you ask in your representation, sir?
lords, to act in terms of the order of the learned single judge. Direction was to, my lords, response 5 and 6 are directed to consider the case of the petitioner for promotion to the post of first division assistant.
First time.
First time, notice. Learned GA accepts notice. How many are there?
Lords,
Will take for all?
Only for our time.
lords, 3 and 4, my lords, are private responses.
Oh, Kalidasa Education Society. All right. GA accepts notice for 1, 2, and 5.
Only for 5.
Only for 5. Only for 5. Notice to 1 to 4.
Please.
Serial number 61.
Yes.
61 and 48 notes go together.
47.
47 words.
61 more, I have bifurcation issue. I have filed I have filed wakalat for the union, respondent number 7. I required some time to file my statement of objection. With regard to bifurcation of the milk union.
All right. Learned advocate for the Union of India is seeking some time.
Milk union,
Milk Union.
Respondent
All
number.
right. Prayed for by so and so for respondent number
7.
7.
Elladharlo.
To file objection.
For respondent number 7.
To do what?
To file my statement of objection to the
In a writ appeal, there can't be statement of
Correct,
objection.
that's right.
Allah, there's an interim order operating. For that, I'll file my.
What is the interim order?
There's an interim order granted now.
The interim order not to take any major decisions, my lords. He can't file objections to a writ appeal. My lords.
Then
If
that
he-
is ex parte, is it?
Yes, Manoj. I was not.
IA is ex parte.
IA is
Order
ex
on
parte.
IA is ex
I order on a application.
Then you will have to file an application for vacating the.
With all the documents.
So you have the benefit of interim order, Mr.
Yes, let it be continued, not till Malanet friend.
Right. Seeks time to file an application to vacating the interim order.
47 ನೋಡಿ date ಯಾವ್ದು ಕೊಟ್ರಿ ಅದು?
Date may be fixed.
ಹೌದಾ?
Date may be fixed.
When do you want, Mr.? After 4 weeks, give a date on 4 weeks. Yes, next.
Yes.
So,
17th April.
Yes, please. My lord, on the last occasion, please note, your lordships have directed me to serve the respondent number 4, who is the contesting respondent. The matter pertains to an writ petition which was filed by the appellants in respect of 27 guntas of land, seeking lapse of the acquisition proceedings for not having taken any action with respect to granting compensation and taking possession, please, my lord.
What happened?
Please,
What happened to that? Your writ petition?
the writ petition is been dismissed on the ground, please, my lord. Para 10,
To the impugned order.
please, ma'am. Please, ma'am, para 10, please, ma'am. The original records were called for, please, ma'am. 16 to notification is there, but insofar as having taken possession of this particular land, please, ma'am, there is no records whatsoever was found in the original records.
Paratan, the question is,
Please,
please
my lord.
read that. As noticed earlier, petitioners had earlier filed writ petition challenging the acquisition.
Please, my lord,
notification.
that acquisition was challenged. That is the validity of the acquisition was challenged before the new act came into force, please, my lord. That was dismissed. That is admitted in my petition itself, please, my lord. I have presented before the learned single judge, please, my lord, that I had filed the writ petition challenging the validity of the acquisition notifications on the ground of HMT case, please, my lord. That was delayed, that was dismissed on the ground that it was delayed and that was done in the year 2011 itself, please, my lord. After the new act came into force, please, my lord, till then that neither the compensation was paid nor the possession was taken in this case, please, my lord. That was my
Where is
contention.
that finding? Please show with regard to your contention, where is the finding recorded by the Honorable Single Judge?
Learned Single Judge, please, my lord. Your lordships could take to page 41, please, my lord. Ink page 41, please, my lord, para 7. Third, the learned counsel for the petitioner, learned senior counsel for the fourth respondent society, learned AGF for the respondent deputy commissioner, so and so, please, my lord. The court has also looked into the original records furnished at the hands of the learned AGA, please, my lord. It should be noticed that this rectification was filed on 25/7/2016 and the grounds have been prepared based on the decision of the Apex Court in Pune Municipal Corporation, please, my lord. This writ petition was filed in 2016, please, my lord. As on that date, please, my lord, the law was a law insofar as this land acquisition matters was concerned, please, my lord. Pune Municipal Corporation was the law, please, my lord. Heavy reliance is sought to be placed on the said decision wherein it was held that the deposit of the award amount in the government treasury would not amount to payment of compensation unless it is paid to the interested person or deposited with the reference code. However, since the decision in Pune Municipal Corporation was reconsidered in Indore Development Authority by Constitutional Bench and it was held that 24(2) of the Act 2013 carves out an exception to section 24(1)(b) where two negative conditions have been prescribed. Therefore, even one of the condition is satisfied, there is no lapse, and such an interpretation logically flows from the Act 1894, read with provisions section 24 of the Act 2013. In that view of the matter, it is clear from the records that an award notice dated 31/5/1991 was issued by the Special Land Acquisition Officer calling upon so and so to receive compensation awarded by Special Land Acquisition Officer. It can therefore be presumed that since claimants did not receive the compensation, the award amounts are found deposited in state treasury. Therefore, the contentions of the petitioner, even in respect of the award amount not being paid to the petitioners, cannot be accepted. Moreover, notifications dated 18
Para 11, para 11 finding, madam. Para 11 finding is that the money is deposited in the treasury, but it must be in 30 proceedings. Notice.
Please, my notice was ordered. We have served on the contesting respondent have filed the proof of service on 16th. My lord, I was having the benefit of the status quo order all along before the writ petition, before the single judge. Regarding the change, not changing the nature of the land.
Who are the other contesting respondents?
No other contesting respondent.
Society there.
They have been served, please.
All right. The advocate for the appellant submits that appellant had the benefit of appellant or appellants?
Appellants, please.
Appellants had the benefit of an interim order injuncting the
status quo order was there.
Order of status quo, full stop. Add interim order of status quo with liberty to seek modification.
Obliged, please.
Permission placed on record on the map code. Add interim order. Yes. Yes.
Benching the order dated 18/7/2018. That matter was dismissed for non-prosecution. Prosecution dismissal. Subsequent, I filed the application for recalling. That order also.
Here, what is the matter on merit?
Merit, my lord, the appellant has not obey the transfer order for transfer to Kolar to Bidar, my lord.
So what happened finally?
Finally, my lord, inquiry is conducted.
Then?
90 days is another absence, my lord, from dismissal from service. My lord.
1 year, it's not one.
As on the date of article of charges, 90 days.
He remained absent for 1 year is the finding of the labor court, page 123, my lord.
The workman remained absent for more than a year from 6/11/98 while confirming page number 123, my lord, para 13, fourth line, my lord. Page 123. The disciplinary authority in the course of the dismissal order has opined that the first party workman remained absent for more than a year from 6/11 to 1998. Observing that, my lord, the labor court confirmed the order of dismissal by rejecting the reference. In fact, my lord, he was issued with an order of transfer.
Workman has not come forward to explain the reasons for absence for a period of 1 year.
1 year.
You did not say anything before the labor.
No. As on the date of article, only 90 days.
Sir, kindly come to page 123.
Yes, ma'am.
First para from the bottom 1, 2, 3, 4, 5, 6, 7.
Yes, ma'am.
Ninth
6,
line.
6/11/1992.
Ninth line.
Therefore, period of another absence, lengthy
When
one.
this allegation was there, why did you not tell the labor code? Sir, it is not 1 year, it is only so such time.
I have made a representation before the annexure D, my lord.
Sir, this is a finding back code.
Yes.
Here, model, you are not, that means it's a deemed admission. And here, writ petition dismissed and you are not gone to court at all.
2009.
In fact, my lord, page 14 on, my lord, may kindly be seen, my lord. The applications were filed after lapse of 1,460 days. And the reason was COVID-19.
Dismissal, my lord. Instead of dismissal, my lord, some benefits, monetary benefits, my lord. Instead of on the basis of that, my lord, notice
The
was
case
issued
of
earlier.
unauthorized.
On the
Where the
basis of
dismissal order is
some
applied.
financial benefits, my lord, on the basis of that.
My lord, the financial benefits would be settled till the date of dismissal, my lord. Except in the case of fake transfer certificate cases, my lord, in the corporation, the terminal benefits are paid, my lord, till the date of dismissal.
You have paid, already paid.
Yes, ma'am.
ಕೊಟ್ಟಿದ್ದಾರಾ?
I don't know, my lord.
ಅವ್ರು ಕೇಳ್ತಿರೋದು ಇಲ್ಲಿವರೆಗೂ.
ಅಲ್ಲ,
No,
ಇಲ್ಲಿವರೆಗೂ
he has not worked, my lord, till the date of.
ಅಲ್ಲ, no work, no salary, madam.
This is a fake
No, except fake TC case ಅಲ್ಲಿ ಮಾತ್ರ ಕೊಡಲ್ಲ, terminal benefits. KSRTC.
ಇದು unauthorized
Unauthorized
absence.
unauthorized.
1 year next plan.
Even in ticket cases.
120 days ಇದ್ರೆ ಸಾಕು unauthorized act.
ಅಲ್ಲ,
CSR ಪ್ರಕಾರ.
As per the annexure C, my lord.
Appellant writ petitioner no, remained absent for more than one. Page 123 na.
123.
Remained absent for more than 1 year. He did not choose to explain the same before the labor. Full stop. Challenging the order passed by the labor court as at annexure N, ID number 58 of 2000. The petitioner filed the instant writ petition.
15th August 2008. ಆದ್ಮೇಲೆ ಏನು ರಿಟ್ ಹಾಕಲ್ಲ, 2009.
As for non-prosecution. As full stop. By order dated 18/7/2018. It is recorded in the said order that on the previous date of hearing also there was no representation. Full stop. ಆಮೇಲೆ ಇದನ್ನ ಹಾಕಿದ್ರೆ ಇದೇನು? All the said order was filed by order dated 35/30 May 2023. The application has been dismissed.
Delay and latches.
On delay and latches. Full stop. Having appeal is filed.
ಇದು 1180.
81 days. 81 days. Full stop. Adverting to paragraph 13 of the order passed by the presiding officer, learned advocate for the, sorry, ಅದಕ್ಕೆ ನಮ್ಮ advocate for the appellant submitted that ಏನ್ ಹೇಳ್ಬೇಕು ನಿಮ್ಗೆ ಇದ್ರ ಬಗ್ಗೆ? ಏನಾರು ಹೇಳೋದಿದ್ರೆ ಹೇಳಿ.
But the corporation was not allowed to work on it. As per the transfer.
ಇದಕ್ಕೆ ಈ ಆರ್ಡರ್ ಇಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇಲ್ಲ IA1 ಮೇಲೆ, ಅದಕ್ಕೆ
ಯಾಕೆ ಅಂತ?
As on the date of dismissal, my lord, IA, my lord, taken into account, my lord.
ಹೌದ್ರಿ, ನಾವೇನಾರು ಒಂದ್ ಬರ್ಸ್ಬೇಕಲ್ಲ ಅಲ್ಲಿ, ತಮ್ದು ಗ್ರೌಂಡ್ ಏನಾರು ಒಂದ್ ಹೇಳಿದ್ರೆ ಅದನ್ನ ಬರೀಬಹುದು.
My contention 35/2023, my lord, onwards the delay does not arise. On IA order on IA, my lord, on 35/2023, my lord.
Correct.
On the basis of that, my lord, there is no
It
delay.
should be all right. Submitted that reckon from the date of dismissal of IA1 of 22 and IA2 of 22 on 35/2023. There is not much delay in filing this writ appeal. Full stop. We may record that the writ petition was dismissed on 18/7/2018. By a detailed order, the application for recalling has been filed in the year 2022. By detailed order, the said applications have been dismissed. Para Srimati Renuka, adverting to para 13 of the order dated, order passed by the labor court into bracket annexure ends, pointed out that the workman had remained unauthorizedly absent for more than 1 year. The labor court has recorded a finding that the workman did not come forward to explain the reason for the absence for more than 1 year. Full stop. ಇದಕ್ಕೇನು ಹೇಳ್ತೀರಿ? 1 yearಗೆ ಇದು ಯಾಕೆ ಹೇಳಿಲ್ಲ? ಅಲ್ಲೂ ಏನು ಹೇಳಿಲ್ವ?
But they have not allowed the reporting for duty at Bidar, my lord. Transfer place, my lord. But the enquiry was going on that time.
No. You see, labor court ಅವ್ರು ಹೇಳಿದಾರೆ, ನೀವು ಇದನ್ನ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂತ. ಯಾಕೆ ಎಕ್ಸ್ಪ್ಲೇನ್
I
ಮಾಡಿ?
have explained, I have given the representation, they explained in the.
ಒಂದ್ ವರ್ಷ ಹೋಗ್ಲಿಲ್ಲ ತಾನೆ?
ಇಲ್ಲ para 12, my lord.
ಒಂದ್ ವರ್ಷ ಕೆಲ್ಸಕ್ಕೆ ಹೋಗಿಲ್ಲ.
ಅವ್ರು allow ಮಾಡ್ಲಿಕ್ಕೆ ಹೋಗ್ಲಿಲ್ಲ ಸ್ವಾಮಿ ಅದನ್ನೇ.
The learned advocate for the appellant submitted that the appellant was not permitted to work. Full stop. In view of the finding recorded by the labor court that no explanation was given before the labor court and non-appearance and the dismissal of the writ petition for non-appearance and subsequent delay in filing the application for recalling and a further delay of 1,100, is the estimate is
1181.
1181 days in filing this writ appeal, we find this appeal is liable to be dismissed on the ground of delay and latches accordingly stands dismissed, no cause.
mentioning for a listing of a matter, my lords. I filed a writ petition, my lords, relating to Shivaram Karanth layout being heard by the special bench Justice Deekshit Nagprasanna. It's coming up on the 22nd, my lords, for final hearing. This matter will be listed along with those, my lords. I'm grateful, my lords.
On submission, Your Lordship. Serial number 42, Your Lordship. It has been urgent for the next week. There is urgency because they're going to declare the election on 22nd, Your Lordship, this tomorrow, if it is Your Lordship taken. Your Lordship, serial number urgency. Your Lordship, day after. Your Lordship, appeal will become infectious, Your Lordship, otherwise. Any date announced? Naliddu, the day after, Monday. Government. Please, Your Lordship. Much.
I'm a counsel by proxy. Serial number 99, the senior designated advocate is before attending the proceedings before the Supreme Court today in an election appeal. May be adjourned by 2 weeks, my lords. 99. I'm a counsel by proxy for the petitioner, appellant, petitioner. I do.
Lordship's kind permission, my lord. Lord, this is for admission.
Which matter?
64 and 66. No.
No, it is 64, my lord.
Komal case.
Please, my lord.
Komal bifurcation tane.
No, this is a,
You are 64, my lord. 64.
no, they are. Amendment.
Then please take it after some time, Mr. Ashwatthama, not possible.
Yes, my lord, my apprehension, my lord, they have issued a notice also to file a contempt petition because this has been.
Srinivasa,
My lord.
you are not filing contempt.
I have not filed, not any contempt. We only requested.
They have issued notice.
He's saying he's in front of you.
That's correct, my lord. They issued notice, that is why I moved it. Now they say that they are not filing it. Let there be a recording, my lord.
Matter is covered by the.
Notice ಆಗಿಲ್ವಲ್ಲ ಇದ್ರಲ್ಲಿ, ಹೆಂಗ್ record?
Notice ಆಗಿಲ್ಲ. That is why even then, my lord, my apprehension is this. There are several.
Sir, please don't waste your time.
No, ಇಲ್ಲ.
Now he's saying that they will not do. ಬಂದ್ರೆ ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ ನೀವು. ಈಗ ಸದ್ಯಕ್ಕೆ 1 ವಾರನೋ 2 ವಾರ ಅಡ್ಜಸ್ಟ್ ಮಾಡಿರ್ತೀವಿ. ಬೈ ಚಾನ್ಸ್ ಅದು ನಿಮ್ಗೆ ಏನಾದ್ರು CCC ಬಂದ್ರೆ ಮೂವ್ ಮಾಡಿ ತಗೊಳ್ತಾರೆ. ಅವಾಗ್ನು ಅವರೇ ಬರ್ತಾರೆ.
In the meantime, my lord, I will accept notice in the other case.
Which case?
Serial number, my lord, 65 and 66.
ನೋಟಿಸ್ ಕೊಟ್ಟಾದ್ಮೇಲೆ ನನಗೆ ಸ್ಟೇ ಸಿಗೋದು ಕಷ್ಟ ಆಗ್ಬೋದು ಬೇರೆಯವ್ರು ಬಂದ್ರು
65 and 67.
ಆಯ್ತು 65, 66 ಗೆ ನಿಮ್ಗೆ ನೋಟಿಸ್ ಕೊಟ್ಬಿಟ್ಟು ಸ್ಟೇ ಮಾಡ್ಬೋದಾ?
ಅಲ್ಲ ಬೇಡ, ಅದು ಮ್ಯಾಟರ್ ಇಸ್ ಆಲ್ರೆಡಿ ಕವರ್ಡ್ ಬೈ ದಿ ಆನರಬಲ್ ಸುಪ್ರೀಂ.
ಅದಕ್ಕೋಸ್ಕರ ನೀವು ಏನು ಮೂವ್ ಮಾಡ್ಬೇಡಿ, ಮುಂದಿನ ವಾರ ಹಾಕಿರ್ತೀವಿ.
I have not moved any.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆರ್ ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ಹಾಕೊಡಿ.
Please.
Yes, next 65, 66 gone. ಮತ್ತೆ 69 up to 69.
64 to
69.
all the 6 matters.
64 to 69, correct.
Obliged, my lord.
Thank you.
At least two government.
What is this
Serial
compliance?
List number one.
List number two.
Well, list number one, serial number two has been passed over.
Correct.
Yes.
So we
Correct,
didn't,
you
we
are-
did
you are
not
right,
want to
but-
pass over, you have said pass over.
Yes.
List number, Karirama. 2 weeks to do compliance. None appears, ಅದಕ್ಕೆ one ನಲ್ಲಿ, two ನಲ್ಲಿ.
Serial number two. This is an item not covered by lordship judgment.
What is the objection now?
Not.
What is the office objection?
Office objection is not regarding translation.
Then it is required.
For not, sorry, matter is covered by lordship judgment. That is in WP number 4319.
Is that correct? Both agree, then covered. We
This is
can't
covered.
adjudicate today. We are very clear, sir. To hear and then pass an order, we don't have so much of time to do that.
Is covered, not
Then please tell him that you should have done that exercise little earlier.
kindly pass over.
Sir,
I have engaged
please, you
senior
must also
counsel.
have some mercy. 150 matters for passover.
It is
When do we take matters?
Lord, it's covered, not kindly
Please
take.
give a copy to him, sir. We have been telling you for
There
3
it is.
times.
Is
Is
there-
it covered,
That
government?
judgment is not yet not released.
Then,
Just last week, not lordships have delivered the judgment.
Your life may kindly have it next week.
No.
Examine.
There is some urgency is involved.
but
The procedures have been-
covered ಇದೆ, ನಿಮ್ಮ ಹತ್ರ ಜಡ್ಜ್ಮೆಂಟ್ ಇಲ್ಲ, ನಾವು ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
Last Monday, not lordships have.
You please show him that number, everything. If he agrees, if it is covered, we'll take it. No problem. Please pass over.
Please, much.
ನೋಡಿ ಅದಿದ್ರೆ ತಗೋಣ, ಇಲ್ಲಾಂದ್ರೆ ಇಲ್ಲ. ಅಮೃತೇಶ್.
Matter. OD has not yet been done, my lord.
Yes, what is, you have to take steps in respect of R6, A6.
We had already taken steps once, my lord.
Then please take steps again. Yes, steps. Fresh steps in 2 weeks. Prabhakar Rao.
Milord, serial number. Milord, what has happened, Milord? Office objection. Annexure D, Milord, page 101. I have filed the translated copy also.
Yes, Mr. Prabhakar Rao submits, office objections have been complied with office to verify.
Now,
and
with
put
regard
up.
to the merits of the matter, Milord.
Now,
Milord.
it will come for preliminary hearing if you have complied with office objections.
Milord, one submission, Milord. There is an order passed by the learned single judge. When the appeal was pending before the Provident Fund Appellate Tribunal.
We have 106 days. Even if we hear it on merit, we cannot do anything.
But my lord, what has happened, based on the erroneous order passed by the learned single judge, they have issued the SOCAS notice and when the appeal is pending.
You tell us what can we do when there is a 106 days delay? Can we pass any ex parte
Lord,
order? No.
let the status quo be maintained that they should not proceed with the orders passed by the learned.
Thank you.
Lord, may I request your lordship may reject my prayer. That is different matter, my lord. Kindly see the page number 17, my lord.
No, Mr. Prabhakar Rao, please try to appreciate there is a delay of 106 days. We cannot and we will not pass such any
But court proceedings are muted, please.
PDA writ appeal. It's come for office objection and my learned friend is arguing on the merits of the case. My lord, this CP Lordship sees a learned single judge's order. My lord, his contention is how can BDA file a writ appeal? My lord, there is direction against us. My lord, 1992, when the plan approval was there, what was mentioned there, my lord, has not been complied. My lord, the association files a writ petition, my lord, against a society saying that you have violated all the conditions imposed by the BD and the layout plan approval. My lord, this is a matter where, my lord, I am also informed, my lord, that the government also, my lord, is in the process of filing a writ appeal.
What is the direction?
Yes, my lord, your lordship may kindly turn to page
We'll
63.
never turn to page number. We have in this court, you must know that you must tell few facts, only then we'll turn the page. What is the direction issued by the learned single judge?
My lord, the direction is declaration of a particular resolution which is to be approved. My lord, which the BDA has not approved, had sent it to the government for approval because of so the government said it cannot be done. It has to be done strictly under the KTCP Act. After that, my lord, the BDA then says, no, it cannot be granted. Subsequently, we also issue them a show cause notice saying that if you leave so and so like civic amenities, it can be done. My lord, it is on this ground, my lord, we have filed a writ appeal challenging the order of the learned single judge. My lord, they're saying that how is BDA aggrieved, my lord? That is, they're saying that this writ appeal is not maintainable. My lord, your lordship may hear and ultimately dismiss a writ appeal, but this cannot be dismissed on the ground of maintainability. My lord.
It's page 47, the direction is that the BDS.
You have no right of audience.
My lord, I don't know, my lord, this matter, surprisingly, my lord, we are the ones who are in a hurry. We don't even move the matter they move the matter, my lord, and get the matter before this court. I'm very surprised, my lord, that how this matter, our own office objections have not been complied. My lord, even the government advocate also, my lord, in the process of filing a writ appeal.
Then you also do the same.
Beg your pardon?
There is an urgency.
ಅಲ್ಲ ನಾವು ನಮ್ಮ ಮ್ಯಾಟರ್ ಮೂವ್ ಮಾಡ್ತೀವಿ ಇದರಲ್ಲಿ ಇದು ಪ್ರಶ್ನೆ ಇದು ಇಲ್ವಲ್ಲ ಇಷ್ಟ ಇಂಟ್ರಿ ಮೋಡ್ ಕೆವಿಯಟ್
week or 2 weeks. Yes. Then what else remains? That's what we had asked for, that only that land.
Please, my lord, may I make one submission, my lord? My lord, my submission, I'm not seeking to pursue the contempt, my lord, but no, my lord, from December 2022, my lord, till July 2023. There was a continuous contempt, my lords, of the order passed by the learned single judge, my lords, wherein visitation rights were granted.
Question is,
Please, please,
if that, then that you work out your remedy elsewhere.
please, my lords, no, what I'm seeking, my lords, before this honorable court is, at least, my lords, for the December 2022 and January first week, my lords, there was visitation where I was entitled for that visitation. I may be compensated for that at least by any Saturday, my lords, I may be permitted to take the child, my lords. I am father, my lords.
That he is taking that, and now it was earlier it was only 4 hours. Now it is full day. That is a modification of the order.
My lords,
You, anyway, it says already January, it has gone.
Please
forget about it.
my lords, no,
What do you, sir, can we modify when you are given an undertaking in some other court?
Please, my lord.
How can we modify that honorable single judge's order in CCC?
My lords, no, my lords, I'm not seeking for a modification of any order, my lords.
Precisely, you are asking for compensation of time.
Please, my
Can we,
lords,
that means modification of that order. Can we do that?
lords, I'll-
That order is not under appeal here. This is a CCC proceeding.
Please, my lord.
Sri Prajwal submits that who had given, accused had given, is it?
No,
who
the
had given that?
Complainant has given an
Complainant had
undertaking.
given, complainant had given an has given an undertaking before Royal Courts of
Justice.
Strand, London, that complainant would not pursue this complaint, full stop. That way the matter, nothing, hence nothing survives, complaint closed.
Served the notice on it. I served the notice.
Yes, sir, only
Yes,
yesterday we got
And I also taken steps, but the last occasion, this was the understanding that.
Nimsha, one nimsha.
7A proceedings,
One nimsha, read order sheet or no, one nimsha. How much money you have to pay?
I had to pay, as an interim order, 25 lakhs I had to deposit.
Sir, when we ask how much money you have to pay, please tell the total figure.
The total figure was 42 lakhs.
42 lakhs.
46 lakhs, 28,808.
42 lakhs. So 42
46 lakhs, 28,808.
46 lakhs. When will you pay 46 lakhs?
The last date of hearing, I gave undertaking saying that I will deposit 5 lakhs before this court and remaining amount in 1.5 lakhs due installments.
So 5 lakhs, remaining is 41 lakhs. Makes if you are
11 is. He was not able to deposit money.
That also you are not deposit.
No minutes. One more.
Dismissed. Learned advocate Sri Ramesreno.
And I'm Srinivas, representing.
Srinivas appearing for Sri Kumar Swami, NR, to a pointed question as to whether the order dated 15/2/24 has been complied. In his usual fairness, Sri Srinivas submitted that the said order has not been complied. Full stop. Appeal dismissed for non-compliance of undertaking. Yes, next. Yes. What is this?
Sir, I have a memo.
Non-payment of court fees, maintainability, that's so and so, maintainability. Yeah, complied with all? ಹಂಗಿಡ್ಬೇಡಿ ಪೇಪರ್ ದಯವಿಟ್ಟು ಯಾವ್ದೋ ಬೇರೆ ಫೈಲ್ ಅಲ್ಲಿ ಇಡ್ಬೇಡಿ ಅದನ್ನ ನಿಮ್ ಪೇಪರ್ ತಕೊಂಡ್ಬಿಡಿ ಕಂಪ್ಲೈ ಮಾಡಿದೀರಾ ತಾವು
Actually, this is
ನೋಡಿ ಈ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ನ ಕಂಪ್ಲೈ ಮಾಡಿದೀರಾ
ಇಲ್ಲ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಲ್ಲ ಇದು ಆಕ್ಚುಲಿ ಇನ್ ಫ್ಯಾಕ್ಟ್ ದಿಸ್ ಇಸ್ ಅಪೆಲೆಂಟ್ ಇಸ್ ಅ ಲೇಡಿ ಎ ವುಮನ್ ಶಿ ನೀಡ್ಸ್ ಲೀಗಲ್ ಏಡ್
ನಾವು ಕೇಳಿರೋ ಪ್ರಶ್ನೆಗೆ ಉತ್ತರ ಕೊಡ್ಬೇಕು
ಇಲ್ಲ ಮಾಡಿಲ್ಲ
ಅಲ್ವಾ
ಮಾಡಿಲ್ಲ
ಮಾಡ್ಕೊಂಡು
ಶಿ ನೀಡ್ಸ್ ಲೀಗಲ್ ಏಡ್ ಅದನ್ನೇ ಹಾಕಿದ್ದೀನಿ ಅದ್ರಲ್ಲಿ
ಆ ಲೀಗಲ್ ಏಡ್ ಅಂದ್ರೆ ದಯವಿಟ್ಟು ಲೀಗಲ್ ಏಡ್
ಅದ್ರಲ್ಲೆಲ್ಲ ಆಗಿದೆ ಸರ್
ಅದು ಹಂಗ್ ಬರಲ್ಲ ಅದು ಲೀಗಲ್ ಏಡ್ ಗೆ ಒಂದು ಅದಕ್ಕೊಂದು ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇದೆ
ಸರ್ ಅದ್ರಲ್ಲಿ ಇದೆ ಸರ್ ಪ್ಲೀಸ್ ಸಿ ದಟ್ ನಾನು ಅದ್ರಲ್ಲಿ ದಯವಿಟ್ಟು ನೋಡಿ ಅದ್ರಲ್ಲಿ ನಾನು ಬರ್ದಿದ್ದೀನಿ
has not been able to comply with the said order, full stop. We had directed ಏನದು?
They have undertaken to pay entire arrears of 93 lakhs.
We had directed, ಅಲ್ಲ ಇದಕ್ಕಿಂತ ಮುಂಚೆ ಎಷ್ಟು ಒಂದು ದುಡ್ಡು
Please
ಕಟ್ಟಿದ್ರು?
note, there is a series of directions since 23rd February.
From June 2023 onwards, my lords, they have been given an undertaking to this court. And my lords, this is unfortunately, my lords, seems to be a case of forum shopping. They are just hoping that, my lords, the bench will change, different orders will be passed. My lords, this cannot be allowed. My lords, it pains us to say this.
No, which
but
is the
my lords,
first undertaking according to you, Mr. Nair?
my lords, the very first undertaking was given, my lords, in June, on 28th of June 2023.
28th of June.
28/6/2023. Before a different bench, my lord.
Yes,
Where
one
he
minute.
admits
Let us just-
that at that time, the arrears were rupees 60 lakhs. He says that all arrears of rent shall be cleared, etc., subject to aforesaid conditions, interim order shall continue. Then, my lord, on the next day, he doesn't comply, doesn't comply.
According to you, one is 28/6/23, then?
From 28/6 onwards, my lord, because this was the undertaking that was continued, has never been complied with thereafter.
All right.
Sir, we paid 1.68 lakhs last after this taking the space.
Have you paid any money from and after 28/6/2023?
From last 4 months, we are not paid. Before that, we are paid, up to that, we are paid.
Sir, please understand the question. Don't waste your time and our time. Have you paid any money after 28th June 2023?
Sir, we have paid.
Where is that?
Sir, we have that.
All.
We were paid, sir. We are given the details.
All right, you can give the details. You do all that later, no problem.
Need another 10 days to complete all the total.
You take as much time as you want to do, you do it, sir. We please, you have done your part of the, whatever you wanted to submit, you have submitted. Please allow us to do our work. Sri Nair, Leonard, Senior Advocate, submitted that that an undertaking was given on 28/6/2023 to clear the arrears of rent by the next date of hearing. And the interim order was interim order granted on 16/1/2023 was continued, subject to the said condition. Thereafter, there has been series of default on the part of the appellants. Full stop.
Lord, Your Lordship may kindly take 13-12 order.
Just hold on, we have got the point. On next para, on 14/2/2024, the learned advocate sought leave to withdraw, sought leave to retire from the case. He was permitted. Dr. Sunil Kumar, one of the directors of the appellant hospital, was present. He agreed to make the payment of rupees, sorry, ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಇನ್ನೊಂದು ಲೈನ್ ಬರ್ಕೊಳ್ಳಿ. On 7/2/2024, it was submitted that the arrears of rent was rupees 92 lakhs. Keeping in view the conduct of the party, conduct of the appellant in dragging the proceeding, as a last chance, sorry, we granted time till 14/2/2024 for payment of arrears of rent subject to cost of rupees 1 lakh. On the last date of hearing, that is 14/2/2024, Shri G. Sukumaran, advocate for the appellant, sought leave to retire and he was permitted. Full stop. Dr. Sunil Kumar, one of the directors of the appellant hospital, again sought time.
For October 27th, we have paid 20 lakhs.
Right. Keeping in view the, for reasons recorded therein, we extended time till today subject to additional, subject to payment of additional cost of rupees 1 lakh. It was made clear that if the payment of rupees 92 lakhs with the cost was not made as on date, appropriate orders would be passed. Full stop. Today, Shri Dr. Sunil Kumar is present. He submitted that appellants are trying to make arrangements and needs 10 days time to make the payment. Full stop. We have perused the order dated 28/6 or 28/6/2023 and subsequent orders passed by this court. Full stop. In view of the continuous default and violation of the undertaking by the appellants, the appeal stands dismissed.
Deeply obliged.
Yes.
ಒಂದು ಅವಕಾಶ ಖಂಡಿತ
ನೋಡಿ ತಾವು ಯಾವಾಗ ಕಟ್ತೀರಲ್ವಾ ಅವತ್ತು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಳ್ಳಿ, ಅದು ರಿಕಾಲಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕು.
ಎವಿಕ್ಷನ್ ಆರ್ಡರ್ ತಗೊಂಡು ಡೆಲಿವರಿ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ. ಹಾಸ್ಪಿಟಲ್ ಖಂಡಿತ ತೊಂದರೆ ಆಗುತ್ತೆ, ಎಲ್ಲ ಇದಾಗುತ್ತೆ. 10 ದಿನದಲ್ಲಿ ಖಂಡಿತ ಮಾಡ್ತೀವಿ.
ಮಾಡಿ ನೀವು ಯಾವಾಗ ಕಟ್ತೀರಾ ಅವಾಗ ರಿಕಾಲಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ನೋಡಿ. ಇದು 28/6/23 ನಡೀತಾನೆ ಇದೆ ಹೀಗೆ. ಸೊ ಅದು ದಯವಿಟ್ಟು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ ಪ್ಲೀಸ್. ತಾವು ಡಾಕ್ಟರ್ಸು ಒಂದು ಕೋರ್ಟ್ ಆರ್ಡರ್ಸ್ಗೆ ಒಂದು ಲಿಮಿಟೇಷನ್ ಇರುತ್ತೆ, ಅದಕ್ಕೊಂದು ಘನತೆ ಇರುತ್ತೆ. ಸೊ ಅದನ್ನ ನಾವು ತಮಗೆ ಕಾಸ್ಟ್ ಹಾಕಿದ್ವಿ ಅಲ್ಲಿ ಅಂದ್ರೆ 1.5 ವರ್ಷದಿಂದ ನಡೀತಾ ಇದೆ. ಆದ್ರೆ ನಾವು ಲಾಸ್ಟ್ ಟೈಮು ಇವ್ರು 1 ಲಕ್ಷ ಹಾಕಿದ್ವಿ, ಆಮೇಲೆ ಇವ್ರು ಬಂದು ಕೇಳಿದ್ರು, ಮತ್ತೆ ಆಯ್ತು ಏನೋ ಹೋಗ್ಲಿ ಅಂತ 1 ಲಕ್ಷದಲ್ಲಿ ಕೊಟ್ಟಿ ಅಂತ ಹೇಳಿದ್ವಿ. ಬರ್ತಾ ಇಲ್ಲ ಅಂದ್ರೆ ಅದಕ್ಕೊಂದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ನವ್ರು ಹೇಳಿದ್ದಾರೆ, ನಾವು ಹೇಳೋದಲ್ಲ. ವೈಲೇಷನ್ ಆಫ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಆದ್ರೆ ನಿಮ್ಗೆ ಫರ್ದರ್ ಆಡಿಯನ್ಸ್ ಇಲ್ಲ.
ಲಾಸ್ಟ್ ಸ್ಟೇ ತಗೊಂಡಾಗಿಂದ 1,60,00,000 ಕಟ್ಟಿದೀವಿ ಸ್ಟೆಪ್ ಬೈ ಸ್ಟೆಪ್.
ಅದ್ರ ಬಗ್ಗೆ ನಾವು ಡಿಸ್ಕಷನ್ ಇಲ್ಲ. ಡಿಸ್ಕಷನ್ 92 ಲಕ್ಷದ ಮಾತ್ರ ಇದೆ.
ಈಗ ಖಂಡಿತವಾಗಿ 10 ದಿನದಲ್ಲಿ ಯಾವುದೇ ಕಾರಣಕ್ಕೂ ಮಿಸ್ ಮಾಡಲ್ಲ. ಲಾಸ್ಟ್ ಅವಕಾಶ
ಅದು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದ.
ಎವಿಕ್ಷನ್ ಅವ್ರು ತಗೊಂಡಿದ್ದಾರೆ,
ಏನ್ ಮಾಡಕ
ಒಂದು ತಮಗೆ ಹೋಲ್ಡ್ ಮಾಡಿ.
ಡಾಕ್ಟರ್ ವಿ ಆರ್ ಸಾರಿ ಅಬೌಟ್ ಇಟ್. ನೀವು ನಿಮ್ದು
10 ದಿನದ ಮುಗಿಸ್ಕೊಡ್ತೀವಿ.
ಯಾಕಂದ್ರೆ ನಿಮ್ಮಲ್ಲಿ ವಕೀಲರು ಇಲ್ಲ, ನಾವು ತಮ್ಮ ಹತ್ರ ಡಿಸ್ಕಷನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಈಗ ಅದನ್ನು ಮಾಡ್ಕೊಂಡು ವಿತ್ 10 days ವಿತ್ ಡಿಡಿ ನಾವು ಬರ್ತೀವಿ.
ಅವ್ರಿಗೆ ಎದುರುಗಡೆ ಅವ್ರಿಗೆ ಕೇಳಿ.
ವಿತ್ ಪೆನಾಲ್ಟಿ ಅಂಡ್ ಡಿಡಿ ನಾವು ಬರ್ತೀವಿ ಸರ್, ಖಂಡಿತವಾಗಿ.
ಸಾರಿ,
ಒಂದು ಅವಕಾಶ ತಾವು ಕೊಟ್ಟರೆ ನಮಗೆ ಆಗುತ್ತೆ.
ನೀವು 1 ಡಿಡಿ ತಂದಿದ್ರೆ ವಿ ವುಡ್ ಹ್ಯಾವ್ ಕನ್ಸಿಡರ್ಡ್. ಇವತ್ತು ಒಂದು ಪಾರ್ಟ್ ಡಿಡಿ ತಂದಿದ್ರೆ ವಿ ವುಡ್ ಹ್ಯಾವ್ ಸಡನ್ಲಿ ಕನ್ಸಿಡರ್ಡ್.
ನೆಕ್ಸ್ಟ್ ಮಂಗಳವಾರ ಅವ್ರು ಬಂದ ತಕ್ಷಣ ನಾವು ನೆಕ್ಸ್ಟ್ ಶುಕ್ರವಾರದೊಳಗೆ ವಿತ್ ಡಿಡಿ ಬರ್ತೀವಿ.
ಇಲ್ಲ ಅದು
ಹಾಸ್ಪಿಟಲ್ ಎಲ್ಲ ಪೇಷಂಟ್ಸ್ ಇದೆ, ತೊಂದರೆ ಆಗುತ್ತೆ. ಒಂದು ಅವಕಾಶ.
ನೋ ದೇರ್ ಇಸ್
ಅವ್ರ ದಾರಿ ನೋಡ್ಕೋತಾರೆ ಬಿಡಿ.
ಥ್ಯಾಂಕ್ ಯು. ಸಾರಿ. ಎಸ್, ನೆಕ್ಸ್ಟ್.
Deeply obliged, madam.
This matter kindly it may be taken up
Which
tomorrow,
one?
Your Lordship. Serial number 46, Your Lordship.
What is 46?
My lord,
appearing for whom?
respondent, my lord.
I'm
Last
appearing-
occasion they said, my lord, they will deposit entire amount.
Not possible.
Tomorrow, Your Lordship.
For what?
Your Lordship, senior will come, Your Lordship, and we'll get the DD also, Your Lordship.
If you are getting DD only senior coming, it will be, we'll record your statement, madam.
No,
We are
Your
very clear
Lordship,
about it.
I've spoken-
We don't even have 1 minute to extra to discuss.
Your Lordship, I had spoken to clients. Client is okay in giving a DD in 2 days, Your Lordship. For
We are not concerned of whether your client is okay or your client is not okay.
No,
Court will pass its own orders.
For 30%, they're ready to give the
Sorry,
DD, Your Lordship.
not possible.
Your Lordship, it can
Time,
be taken up tomorrow.
30% is not, if you are prepared to give if you give an undertaking, if you want to go telephone, come back and tell us. If you are prepared to deposit the full DD tomorrow, we'll adjourn it. Otherwise, we are dismissing at the end of the day. Thank you. You can find out from your client, take instructions, do what you like. We will not keep that to the security guard. They are not ready. ಯಾವುದು 70 ರೇಮತುಲ್ಲಾ ಕೊತ್ವಾಲ್. Yes, what is this?
Your Lordship, the statement of objection filed by the party, I haven't received that. May I get a copy of the statement?
All right.
So we have sent a lot.
Learned advocate submits that statement of copy of statement of objection not received by her 2 weeks. Yes, Ananda.
For the petition. So the petitioner filed a representations before the respondent, number 1, 3 to 5, are requesting to protecting the government land. Not the respondent number 6, under the guise of the plan issued by the 5th respondent.
First thing is, who are you?
Not,
Who are you? What is your occupation?
I'm a graduate, my lord, I'm self-employed.
So what is the prayer here?
Prayer to consider my representation.
It's of no consequence. What have you asked in the, why don't you have little mercy on us? When we ask every lawyer, please tell us in 4 sentences, what is your case?
But I filed a representations before.
What did you write in that?
I consider to take actions to the 6th respondent who encroached the government land and the
6th respondent.
6th respondent. And the encroach the buffer zone area of the Rajakalve in survey number 76 of Kodagi Tirumalapura village, Elanka Taluk.
How do you know this? You are situated, you are staying in Kunigal Taluku.
Please. I'm an active member of the this.
This R6 is in Bengaluru.
Please.
How do you know that he has encroached?
I'm the member of the Dalita Sangarsha Samiti, my lord. It is in office at Allal Sandra, GKVK post and the Elanka village, Elanka Obli. My lord, based on that, my lord, we came to know that, my lord, the encroach the government land, survey number 26.
See, Mr. Anand, you are filing a litigation in your individual capacity.
Please.
In a public interest.
Please.
You are in station A. The station B is 60, 70 kilometers, not even 70, even more than that. 80 kilometers beyond. How did you realize that so-and-so in a place, can anybody just think that, you see, in Tumkuru, somebody has encroached the land?
But, my lord, as per my instructions, my lord,
Sir, we ask questions.
Please,
So you must kindly answer this question. These are very fundamental.
Being a member of that Dalita Sangarsha Samiti, my lord, he came to know that.
So whose cause it is? If you are a member of a Samiti and if Samiti has got privy to some information, whose cause it is?
Initially, my lord, the secretary of the Samiti filed a representation. Later, I filed a representation.
If Samiti is pursuing, that's a different matter.
Samiti is.
You have some grind to acts.
Samiti filed, kindly see the first representation filed by the Samiti at annexure 30, page number 33, annexure G. It is filed by the secretary of the
So
Samiti.
please confine yourself to you. You don't worry about the Samiti, etc.
And later on, the Samiti is authorized to pursue the matter.
Sorry, Barkman. Prayer in this petition, prayer in this public interest litigation is to consider the representation. Consider his representation at annexure?
Annexure G2.
Not G2. Where is your representation?
But in my representation, they have furnished the information that they have not sanctioned the plan, not issued the kata, etc.
Where is your representation?
Page number 50, my lord.
50.
50. They furnished the information.
All right. To consider representations at annexure, first G in the G2K. The said representations are filed on behalf of, who is Guru Swami?
He is the secretary of the Samiti.
Guru Swami. Dalita Sankarsha, by one Sri Guru Swami, Dalita Sankarsha Samiti. Into full stop. To a point, the petitioner claims to be a, how you are described. You see, in public interest litigation, you must first describe yourself.
I described in page number 16 the particulars of the petitioners. The petitioner is a graduate.
Petitioner has described himself as follows, para 2. The representations are submitted by the Samiti which is situated in Bengaluru. Petitioner is a resident of Tumakuru. To a pointed question as to how ಎಲ್ಲಿದೆ ಇದು ಇದರಲ್ಲಿ ರಾಜಕಾಲುವೆ ಏನ್ ಬರ್ದಿದ್ರಿ ನಿಮ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅದೊಂದು ಪಾಯಿಂಟ್ ಯಾರು ಹೇಳ್ಬೇಕಲ್ಲ ಎಲ್ಲಿದೆ ಅಂತ.
The representation earlier, my lord, become Samiti itself is gave a representation.
ಅದ್ರಲ್ಲಾದ್ರೂ ತೋರಿಸಿ.
I say kindly see the page number 36, Annexure G, page number 33, my lord.
ಎಲ್ಲಿದೆ ಅದು? ಯಾರು ತಗೊಂಡಿದಾರ? ಅವ್ರ ಹೆಸರು ಬರ್ದಿದ್ದೀರಾ ನೀವು? ಮಿಸ್ಟರ್ ಸೋ ಅಂಡ್ ಸೋ ಇದನ್ನ ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ. When you have made him R6, what is the allegation against R6?
He's encroached the government.
Please show that in that line, mister, where you have written.
We are not mentioning the name, but constructions ಎಲ್ಲ ಹೇಳಿದ್ದೀವಿ ಸರ್. ಈ ತರ ಕಟ್ತಾ ಇದ್ದಾರೆ.
Mr. Anand, you are a responsible
Please,
advocate,
my
I
lord,
suppose.
sorry. As per the, my lord, they
You
represent.
are now inviting costs from us.
Sorry, ma'am. Sorry, ma'am.
Whatever you want, you can do.
Sorry.
You have not made any allegation against him. We are asking you very repeatedly.
No, my lord, our number ಎಲ್ಲ ಬರ್ದಿದ್ದೀವಿ ಸರ್.
ಯಾರ್ number?
ಇದು 6th respondent phone
ಎಲ್ಲಿದೆ
number.
ಅವ್ರ ನಂಬರು?
ಈ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ತಮ್ಮಲ್ಲಿ ಕೋರಿಕೊಳ್ಳುವುದೇನೆಂದರೆ ಮೇಲೆ ನಮೂದಿಸಿರುವ ಸರ್ವೆ ನಂಬರ್ 137/1 ಹಾಗೂ ಸರ್ಕಾರಿ ಜಮೀನು 76ರಲ್ಲಿ ಬೆಂಗಳೂರು ನೀರು ಸರಬರಾಜು ಇಲಾಖೆಯವರು ಅಳವಡಿಸಿರುವ ದೊಡ್ಡ ಸಿಮೆಂಟ್ ಪೈಪ್ ಅಳವಡಿಸಿದ್ದು ಈ ಪೈಪ್ ಹೆಸರುಘಟ್ಟ ಕೆರೆಯಿಂದ ಬೆಂಗಳೂರು ಕಡೆಗೆ ರಾಜ್ಯ ಹೆದ್ದಾರಿ ನಂಬರ್ 1 ಹಾದಿಕೊಂಡು ಹೋಗಂತೆ ಇದರ ಮೇಲೆ ಖಾಸಗಿ ವ್ಯಕ್ತಿಗಳು ವಾಣಿಜ್ಯ ಕಟ್ಟಡಗಳನ್ನು ನಿರ್ಮಿಸಿದ್ದು ಪುನಃ 1ನೇ ಮಾಡಿ ನಿರ್ಮಿಸುತ್ತಾರೆ. ಈ ಸೊತ್ತುಗಳನ್ನು ಬಾಡಿಗೆ ನೀಡುವ ಸಲುವಾಗಿ ಬೋರ್ಡ್ ಅನ್ನು ಸಹ ಹಾಕಿದ್ದು ಸದರಿ ಬೋರ್ಡ್ ನಲ್ಲಿ ಫೋನ್ ನಂಬರ್ so and so ಎಂಬುದಾಗಿ ನಮೂದಿಸಿರುತ್ತದೆ. This phone number belongs to the 6th respondent.
How do you know that it is in the government land or in buffer?
I have produced the photographs. Your lordship kindly see where
Can
it's
by a photograph anybody make out that whether this is a surveyed land, in which survey
ಅಲ್ಲಿ
number, which is there?
ಪೈಪ್ಲೈನ್ ಇರೋದು ಗೊತ್ತಾಗುತ್ತೆ ಸರ್. ಆ ಪೈಪ್ಲೈನ್ ಮೇಲೆ ಅವರು ಬಿಲ್ಡಿಂಗ್ ಕಟ್ತಾ ಇರೋದು. Photos kindly see the annexure. B.
To a pointed question as to what is the allegation against respondent number 6, learned advocate submitted that in the annexure G dated 22/7/2023, the Samiti has stated that some construction was put up in a land and the building was offered on rent with full stop. Three phone numbers were mentioned on the building. And according to the petitioner, they said phone numbers belong to the respondent number 6. He further submitted that according to the complainant, the Samiti has submitted, given representation as per annexure G stating that the constructions have been made ಎಲ್ಲಿ ರಾಜಕಾಲುವೆಗೆ ಅಂತನಾ?
ಹೌದು ಸರ್.
ರಾಜಕಾಲುವೆ ಮೇಲ್ ಮಾಡಿದಾರ?
ರಾಜಕಾಲುವೆ ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡು ಮತ್ತೆ ಪೈಪ್ಲೈನ್
by encroaching the ರಾಜಕಾಲುವೆ. Full stop. In substance, petitioner's case is that respondent number 6 has encroached Raj Kalwe in Bengaluru. There is no specific complaint against him in annexure G. Full stop. As recorded here, now petitioner is a resident of Tumakuru and the land in question is situated in Bengaluru. Full stop. We find no public interest in this petition. Bills dismissed, no cause.
Public.
We have complied the order.
Which one?
Insofar as 72 is concerned, Lord's,
Is it complied?
Lord, order is passed, my lords, there is no, my lords, dispute over it. But my lords, issue of, my lords, approval of promotion.
Asking you a question. Is
Lord,
it
it has been
complied?
complied.
Then no
Complied.
further discussion on that.
Your lordship, my lords, reserve liberty, my lords, to pursue for other remedies, my lords, because they have approved.
What remedy?
My lords, there was, my lords, promotion of 2016, order of Leonard Singhal judge in 2023 July, my lords, approval, directing them to do it within 2 months is done, my lords, in the month of,
Whether that order has been complied or
order
not.
has been complied, my
And
lords.
that's all.
My lords, I have to get financial, my lords.
That's a different cause of action.
My lords, that liberty, my lords, may
Why
be
do
reserved.
then we must record a finding, then the liberty is given. If you want to challenge that endorsement, no, we can straight away say yes, liberty. You're a senior person. Full stop. Barkul. Srikanth submits that the order has been complied. Complaint closed. Next, Mutana.
Filed a memo.
All right. The GA has filed a memo. The same be kept. GA has filed compliance memo. Mr. Srikanth submits that the order has been complied. Complaint closed. Mutana.
I pay for the appointment, my lord. In the case is, my lord, that officer of State, erstwhile State Bank of Mysore, now State Bank of India, he was imposed with the punishment of compulsory retirement. As per the pension regulation, he is entitled for 2/3 pension. And in this case, my lord, this the learned single judge has ordered for full pension.
2/3 kottidira.
2/3 kottidara. He is getting from, he is getting 2/3.
Why he is not entitled?
No, the regulation says like that, my lord. In this case, my lord, this order was passed in the month. Regulation pension.
So if they.
My lord, pension regulation.
You are entitled.
Lord, regulation permits, Lord, there are two words. Lord, under regulation 33, subclause 2, there are two situations.
Pass on the regulation.
No, then hearing has to, you don't agree with that, no? No, then the hearing has to be done. Admit.
My lord, in this case, my lord.
Delay, can we condone the delay?
Delay can be
Yes.
condoned.
Mr. Nayak has no objection. I even allowed delay condoned. Admit.
My lord, in this case, my lord, I prayed for the interim order, my lord, because what happens, my lord, this order was passed in the month of September. And at that time, it appears that facts were not brought before the honorable single judge. But same matter of the State Bank of Mysore in different cases of same officer, it came in the month of November. November, my lord, all the facts were presented before this honorable learned single judge. And this single judge has passed the order stating that he is entitled for only 2/3, not full pension. That order also I am enclosing, my lord, it is enclosed. So in the same, learned
Two distinct orders. In
order, yes, my lord.
All right.
And interim order, my lord, because on the basis of this
All
order.
right, interim order. Yes, next. I heard interim order, I had to dispose of. Yes, what is this?
My lord. I am the party in person, madam.
Yes. What is this CCC? Which order is violated?
Annex A, my lord. Page number
That
29.
order? What is the direction in that annexure A?
Annexure A, page number 29, para 40.
Petition promotion. Nimge promotion beka?
Yes, my lord. I already retired, my lord.
You are retired.
The consequence benefit, they agreed in division bench, 8 weeks.
Notice.
Emergency notice,
Correct,
my
correct.
lord.
Correct ಇದೆ, notice. What is the matter, Ravi?
It's a driver against whom the proceedings were initiated for unauthorized absence. Lords, when the proceedings were pending before the Labor Industrial Tribunal, Lords, they initiated proceedings under 33(2)(b) for the very same misconduct and have discharged me. That was the issue which was raised before the learned Singh. Lords, ultimately the Labor Tribunal said that the cause which is shown does not come under 33(2)(b) and did not accept, Lords, the contention that I require to be discharged. That was challenged by the corporation before this honorable court. That's the learned single judge. So the learned single judge doesn't, if your lordships were to take page 19, the learned single judge simply extracts the orders of the labor court and says that since there is a compliance with the requirements under 33(2)(b), nothing more is required to be considered. But my lords, the Honorable Supreme Court says that the misconduct for which the discharge can be undertaken under 33(2)(b) should not be connected with the dispute which is pending before a concerned authority. Of course, that is the explicit language under 33(2)(b) proviso, my lords. As a delay, I will just take out notice. There is no reason which is independently assigned to set aside the order.
See, the Honorable Single Judge has.
Para 7, my lords, it only says 33(2)(b) is complied with, but the question is, what was the question raised is whether it is pertaining to the same misconduct or a different misconduct. That is not dealt with by the learned single judge.
Then nobody may have argued that matter.
My lords, this is precisely what is observed by the industrial tribunal. My
And
lords.
file a review.
Lords, that's stated by the industrial.
File a review before the honorable single judge.
I will take that chance, my lords,
Ah,
because
you
there was a delay. I just
That's
came
a
before
different
lords.
matter.
Very well.
After arguing the matter for some time, learned senior advocate seeks leave to withdraw this appeal with liberty to file a review before the honorable single judge.
Lords, it's great.
AOR has filed a memo. We kept in record. Appeal dismissed with liberty as prayed for. Next.
My lord, I appear for complainant in this case, my lord. My lord, in this case, my lord, the direction is at page number 51, my lord, where the respondents were directed to consider the representation within 8 weeks, my lord. Now, my lord, pursuant to the said direction, I have given representation on 15 June 2023, my lord.
So what is that direction?
My lord, direction was, my lord, with regard to the refund of GST, my lord, we have paid, the employer has to pay refund the GST what we have paid to the
Correct.
department.
Notice. Correct. Notice.
Much obliged.
Vishala Raghu. None appears. Yes, next.
The appellant has challenged the proceedings before the land tribunal. Not occupancy rate was granted, and that was challenged before the learned single judge. Learned single judge, on the basis of the compromise, and he has set aside the order. That was challenged before the honorable division bench. Division bench has made an observation. Compromise is impermissible. Anyway, only between the two parties, government is having right, and also other family members conferred the occupancy rate in their favor. He filed an application before the Tahsildar to issue form number 10 in accordance with section 55 of the Land Reforms Act. And instead of the issuing the form number 10, he referred the matter to the land tribunal. In the land tribunal, he has filed one person who has claimed to be a purchaser, filed an application, impleading application was allowed. But my suit for partition is pending. There also he filed an application. But according to me, the once occupancy rate is confirmed, land tribunal has no jurisdiction. Only Tahsildar has to follow. It is only a mechanical order in the sense, it is a ministerial order. He has to follow the order passed by the land tribunal and issue form number 10.
What happened in the writ petition?
Writ petition, we filed a writ petition challenge. Learned judge, wrongly, my respectful submission is, it is not properly understood. Please come to page 21 and para 8. It is, with great respect, it is not properly understood. But what learned judge says is, page 80 may kindly be seen. My application is to issue form number 10. Please take page 80. And learned judge is under the impression, I filed an application for grant of occupancy rate, page 21, para 8. Division bench has made an observation that as against the persons who are not before the learned single judge, it is not binding them. Occupancy was conferred in their favor, and therefore I filed an application before the Tahsildar to issue form number 10.
We
That
understood
application
that.
is at page 80.
Now the question is, once that application was filed, your problem is he again referred it to land.
Land tribunal has no jurisdiction under section 55.
The tenant or the landlord?
an application for
all this, you find out. Honorable single judge has rightly, in our view, he has rightly said that interest has to be protected.
No, please see
We are-
section, Malad, please see para 8 and also.
You can, what is the worst that the honorable single judge done? What he says is, I am of the view that R3 has to be heard in the matter. That's all.
No, that the land tribunal itself has no jurisdiction is my respectful submission. His remedy is either civil court or in the partition suit. But the land tribunal cannot be given jurisdiction which has no jurisdiction at all. Section 55, you last may kindly say. Once 48A.
You know that
land.
we understand.
Yes, it carried out.
So the honorable single judge has exercised his jurisdiction at 226, saying so much. Ultimately, what is it that he has dismissed? No.
He has dismissed, but now question is, land tribunal has resumed the proceedings. Now they are going to pass an order, second order. It is impermissible under law. That is why I challenge even the proceedings also.
Then the persons, whoever has given you this compromise, who have offered compromise in the previous round of litigation.
I am not a party there. That is the problem. I was not a party before the learned single judge. I filed an appeal because I am one of the sharers. My partition suit is pending. Then I filed a writ appeal before the Honorable Court.
So who came before this court?
But the respondent. Please, one of the family member, but he claiming to be the thing, he filed an application. Please see, please come to page 67. Page 67, para 2 nalli, sorry, page 68 may kindly be seen. Respond number 5.
The order correct this.
Respond number 5. But land tribunal.
Court R3 though, he can't be thrown out like this.
Court cannot confer jurisdiction to the land tribunal, which has no jurisdiction under the statute. His sale deed is also challenged in the partition suit.
Which partition suit?
The appellant herein has filed a partition suit for partition, not only this property, several other properties.
So very good.
He filed an application.
Very good, your right should be confirmed.
He filed an application there to implement himself as a party. He is a party there.
Right.
Suppose if he succeeds in to prove that
So
he has,
we will record that.
His brother has sold the property. His right is to seek the appropriate relief in the final decree proceedings in the civil suit, because he has sold it.
Oliver will be happy.
Therefore, now the land tribunal is seized of the matter. Land tribunal cannot do it. Only the civil court can decide this.
notice for ಎಲ್ರಿಗೂ ತಗೊಳ್ತೀರಾ? ಇಲ್ಲ. One ಮಾತ್ರ. One notice to others. Notice to 2 to 4.
Obliged. 81, my lord, I may be permitted to represent the petitioner.
Withdraw.
Petitioner, I am permitted to represent, I hold no color of Milan disease.
You're withdrawing?
No, my lord, I am arguing.
You're appearing?
Yes.
All right.
Lord, Annexure A, my lord, is the closure direction issued without complying, my lord, the mandatory provisions of the Rule 34. Rule 34 requires, my lord, a proposed direction could issue, they should issue notice of proposed direction, NPD. They have not issued.
Suddenly, without that, annexure A is passed.
Yes, my lord, yes.
That's here, that's, I do not know which page number, that's the
Page number-
second page of the closure order, that's the petitioner industry is operating without even consent.
Yes.
Now, that's all these formalities would come of even giving them an
If
action.
you had a,
If you had a consent, that's the entire issue here is that, that's may take, that's
My
the second
submission,
page of the impugned order.
page,
Page 14, my lord, page
40 minutes, unnumbered second paragraph. As per the records of the board, the said unit has not obtained the consent of the board.
yes.
No, my submission, my lord.
Did you have a?
No,
consent?
no.
Then correct.
My one submission, my lord. It is a industry involving fish cutting, my lord, traditionally employing about 50 women, my lord. My lord, very recently, my lord, they came to know about obtaining consent and they have applied for consent. Suddenly, my lord, they are closing, my lord, it will have cause.
That's even.
They will let them issue, my lord, notice of, it also applies.
It notice ಬರಲ್ಲ ನಿಮ್ಗೆ?
No, kindly see, my lord,
He is
section,
correct.
they quoted kindly see, my lord, they quoted section 33A.
I can close only that section.
33A, my lord, they have invoked power.
Prima
Yes.
facie, if you had a consent, then you see, they will say, look
No,
here, we are giving you a consent, what have you got to say, etc. You are
No, kindly,
completely an outside,
This is
you are
not- that is
violating.
not the
you are
condition.
closed, Isn't it?
No, my lord, that is not the condition. My lord, 33A, when they invoke, they should follow 34.
No.
Kindly see, my lord, 30, I'm sorry,
In
33A.
the case where the consent was there.
Not necessary, my lord, when they want to issue, kindly see 33A. 33A.
That's before.
No, I'll
33A,
submit.
that's consent ought to have been obtained under section 25.
33A, kindly see.
That's without that, that's the operating industry.
Lord, I will-
Admittedly,
Lord, I will, 30,
Ah.
for invoking, sorry.
Admittedly, they're saying that they are running an industry and they did not know that consent was ever required at all. And they have applied now. If that be so, let them process the consent application.
Correct.
And go ahead with it, In fact, my lords had taken a similar view 2 weeks ago. The judgment is not yet out, I can give the copy of the writ petition order, where the AG had appeared. to the
Sorry, my
court.
lord. 33, I'll read, my
The
lord.
consent was not there. Consent for establishment was not there. And they had given an undertaking that we will not.
Correct.
33A, I will read, my lord. This is not the requirement.
Yes.
Notwithstanding, kindly mark, notwithstanding anything contained in any law, in other law, but subject to the provisions of this act, and to any direction that the central government may issue in this behalf. A board may, in the exercise of its powers and performance of its functions under this act, issue any direction in writing to any person, officer, authority, and such person, officer, authority shall be bound to comply with such directions. Then, my lord, the closer, for the explanation, my lord, for the avoidance of doubt, it is hereby declared that the power to issue directions under this section includes power to direct the closer.
Yeah,
Not-
invoke which
Not is
provision?
serious consequences. my lord.
We have issued, we have invoked section 33A,
Now, my lord, 34A, 34 rule reads like this, my lord, kindly.
That's my only submission is that,
Now, I will complete, my lord, sorry, my lord. My lord, 34, my lord, just pass on the rules, my lord. 34 rules, my lord. I have copy.
Yes.
Copy I have, so just.
ಏನ್ ಹೇಳಿ ಪ್ರಪೋಸಿಷನ್ ಹೇಳಿ ಸುಮ್ನೆ
34, my lord, it is a mandatory, the provision, my lord, to issue notice of proposed direction before we issue 33A.
In which cases?
In all cases, there is no
Please show.
34, just a minute.
effectively, they're saying that without consent, allow us to operate the industry.
Not possible.
Kindly see, my lord, 34.
What is 34? They are given some paper, there is
No,
no
rule
34.
30, that's amended. I will show.
That's look at
34
page
here.
14.
I will show him, I will show him, just a minute. 34, page number 14, my lord, bottom, page number 14, bottom, otherly.
See, in this court, you must mark, you must bring the paper perfectly. ಸುಮ್ನೆ ನೀವು time waste ಮಾಡ್ತಾ ಇದ್ರೆ ಕೇಳಲ್ಲ ನಾವು. There is no 14.
That's bottom right side. of
Bottom
the-
page 14, my lord.
Bottom page 14.
30, Rule 34 reads, my lord, is amended in the year 93.
Yes.
Any direction issued under section 33A shall be in writing.
Please mark in this in red pen
Sorry,
and then
sir.
give it to us. Why are you wasting our time like this?
Sorry, this is some. Just a minute.
Yes, what do you say, Mr.?
34, my lord.
That's,
34
this is a
three.
situation, my lords. It's an ideal situation where they had.
All right. But now please 34.3.
Yes, ma'am. It's 34.3, ma'am. That's the person officer on to whom any direction is sought to be issued shall be served with a copy of proposed direction and shall be given an opportunity of not less than 15 days from the date of service of notice to file with officer designated in this behalf.
So the opening is any direction issued under 33A shall be issued or served with a copy of the proposed direction and shall be given an opportunity of not less than 15 days. What
Yes,
I got to say for this?
Well, that's I'll be repeating. Let's make once a request. Let's let this 33A be treated as a show cause notice. Subject to what petitioner said. Until that is heard, let them not operate their industry.
Of course.
Lord, I will running.
You
unit,
can't
my lord.
operate. You have no
Lord,
consent.
my lord,
If you
one
are-
submission,
he is
otherwise,
very
my lord,
fair- He is very fair at that.
my lord, otherwise, my lord, this
Violator-
order must go, my lord.
Violators of law will not get any
But
relief.
kindly see, my lord, two more aspects will complete.
No,
my lord.
this is one aspect is enough. We are-
Kindly appreciate, my lord.
we would have simply dismissed this.
Lord.
People who pollute, we have had.
No pollution, my lord. I am sorry, my lord, there is no pollution, my lord.
That's a different
Except
matter.
not having consent, there is no
Go
pollution.
and give him.
My lord, running unit, my lord.
ಇಲ್ಲ, ಇಲ್ಲ, ಅದಾಗಲ್ಲ.
My lord, 60 women are working, my lord, on a daily basis, my lord. Fish, ಇಲ್ಲ, pollution ಆಗಲ್ಲ, sir.
See, Mr. Nagaraj, this is the only order you will get. If you want, you can take it. Otherwise, you don't exercise our jurisdiction in pollution control matters.
Lord.
Perfect.
Lord, my submission, my lord.
In his usual fairness,
Lord, one more submission, my lord. I have filed, my lord, the past, annexed D, my lord, I have filed application for consent. Let them expedite.
It's all right. That's a different cause of action.
May observe, my lord. This I have annexed also.
ಅಲ್ಲ ಅದು ಹಾಕಿದ್ರೆ ಅದಕ್ಕೆ ಅವ್ರ ಹತ್ರ ಹೋಗಿ
ಅಲ್ಲ ಅವರು ತುಂಬಾ ಟೈಮ್ ಮಾಡಿದ್ರೆ ಅದಲ್ಲ.
ಅದ್ ಮಾಡ್ತಾರೆ ಅವ್ರಿಗೆ methodology ಇರುತ್ತೆ.
There is other
ಅದಕ್ಕೆ
considerations. Lord.
ನಾವು
2 weeks.
ಸರ್ ಫ್ಯಾಕ್ಟ್ಸ್ ನೋಡಿದ್ರೆ ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಹಂಗೆಲ್ಲ ಆರ್ಡರ್ ಬರ್ಕೊಡ್ತಾರೆ.
Kindly I have produced, my lord, annexed D, my lord, an application submitted for consent.
ಸರ್ ನಾಗರಾಜ್ ಪ್ಲೀಸ್ ಹ್ಯಾವ್ ಸಮ್
4 ತಿಂಗಳು
ಮರ್ಸಿ ಆನ್
ಆಯ್ತು, 4 months ಆಯ್ತು. ಫಸ್ಟ್ ಅಕ್ಟೋಬರ್ ಆಗಿರೋದು 4 months ಅಲ್ಲಿ ಮಾಡ್ಬೇಕು ಅವರು. ಅದೇ ಡೀಮ್ಡ್ ಕನ್ಸೆಂಟ್ ನಮಗೆ. Section 24, 25, 7 kindly see.
Please stop.
Lord,
We have been requesting, please have some mercy on us. We want to dictate the order. How many
mentions the suppression of the previous amendment that was made at, on 6/3/2018, Your Lordship.
What is 6/3/2000?
6/3/2018, that is, annexure C, Your Lordship, page
What is-
number 41.
What is that?
Your Lordship, there is an amendment made to the previous,
Annexure C,
page number 41, Your Lordship.
41. What precisely you want? What is your prayer?
Your Lordship, the respondent number 2 has passed an order which, a recommendation letter on 15/10/2020, Your Lordship.
State government has given a recommendation.
Yes, Your
So,
Lordship, stating that whatever, the activities that we are running right now in the premises is permissible activity as per the CRZ notification, Your Lordship. And within the given time, as per the CRZ notification 2018, the amendment notification, we have again reapplied for it on the annexure F, Your Lordship, page number 55.
What has happened?
Page, it clearly states, the respondent number 2 clearly states that it may be kindly considered and ratified.
Post back to approval.
What is
Please
said?
give him.
The state government has asked me to consider. I cannot consider in view of the interim order passed. Manoj.
Your Lordship, the
If
interim order
WPL
that
by
is
the
passed
Madras-
by the Honorable High Court is nowhere in concern to our,
Manoj, this is the only circular which permits me to give CRZ approval post facto. Apart from this, there is no provision in law in CRZ regulation to give post facto approval. Manoj.
Where is that OM? Let us see.
Your Lordship, annexure G, Your Lordship, page number 58. Nowhere in this,
1 minute. 58.
yes, Your Lordship.
This is the OM, is it?
Yes, Your Lordship. It nowhere suppresses the,
No, no. What the learned advocate is saying is, I have no problem. I'm prepared to give you
yes,
the post facto approval.
yes.
But my hands are tied because this has been stayed by Madras High Court.
Manoj, I will place this order on record. Manoj, Thursday it may be taken up.
Your Lordship, I have
Order I'll place.
the,
You have the order.
yes.
Give it. Give that order. certificate for, letter CGC submitted that the issue is pending. Sorry, the OM dated
19 to 21.
19 to 21. And please show under 19 to where you have that permission to consider. This is the OM, no? 19.2 is the
Yes,
OM?
your lordship.
19.2, which is the OM, madam?
21 is the OM. An extra F.
Which is your last OM which has been stayed according to you?
An extra G. Page number 58. This is the official memorandum which is currently stayed before the Honorable High Court of Madras and Bombay, your lordships.
In 19 to 2021 has been stayed by the Madurai bench of Madras High Court. Therefore, Union of India is, the central government is unable to process petitioner's application. Full stop. She seeks time to make further submissions as to whether notification dated 6 March 2018 was also under challenge. All right. Next week or week after next.
Yes, lot of deemed extension, lot of the foreign lease. Lot has past orders not regarding deemed extension.
Okay.
Otherwise, not this issue has not been decided in the earlier.
Yes.
My lords,
Yes, please.
yes, my lords. I am for the petitioner.
Yes, what is this matter?
This is about the continuation of the query lease, my lords. I was granted a
This
query.
petition is premature. They are challenging interdepartmental.
No, with all respect, let me submit. On the last round of occasion, my lords, I had submitted that I was granted a query lease way back in the year 2005 on obtaining revenue NOC, forest NOC, environment clearance certificate. Again, my lease was under deemed extension. It was extended till
Then
2035.
it may require some hearing, sir. Please take it after some time, get it, or you argue on that date.
Maybe any date in the next date,
Yes.
next week, my lords.
Next week, difficult, sir. We have loaded a lot of matters, 10 days.
But in the meantime, some interim protection that they
No,
should
sir.
not disturb me. Some interim relief, my lords, because I am holding the.
Are you disturbing him?
Yes, my lords.
Government
They have
advocate says
stopped
that,
it.
government advocate says that they are not disturbing you.
Let it be observed, my lords.
No, not.
But
What is challenge
I
is
think
interdepartmental.
next week, what do you will?
Though at such a time, I'm holding the lease, my lords. Validity is up to 2035.
Sorry.
I cannot be denied the benefits of the lease, my
Sir,
lords.
you wanted next week, we are giving you next week, no problem.
Please, ma'am.
May not
Serial
take
number.
2 minutes, my lord.
Sorry, not possible.
Serial number 100, my lord.
Tomorrow, my lord.